I had communicated your lordship's order to the university. The university is ready to reinstate the respondent with certain conditions. But that condition I am putting before your lordship for your lordship's consideration.
What are those conditions?
Those conditions are because
who is your opponent?
Taking into my friend.
Your brother is saying that he will reinstate your objection.
But they are stating that they have put on certain conditions.
What are those conditions?
That has not been informed to me.
What are the conditions?
The conditions are that taking into the past conduct of the employee concerned, the university is ready to reinstate her, but he will not claim the salary during the period from which he has terminated till the date of reinstatement.
How much? What is the length of that period?
October 2023. 2023, the petitioner was put to compulsory retirement.
And reinstatement is?
Reinstatement order is, my lord, has been dated 14th of May 2025.
What time has been granted for reinstatement?
2 weeks.
14th February?
14th May.
May,
my lord.
Of?
2025.
25.
That the direction was given for reinstatement by the Honorable Single Judge. That is subject to the appeal. That order is subject to the appeal. You can reinstate her on the date your lordship directed. But during this period, he has not worked. She had not worked.
But you have kept her outside. What she should do? If you close the doors, and if you say you have not,
we have not closed the door. The termination order was.
What do you say about this? Instead of
having a foundation.
One second.
Yes.
Now, there is some proposal from the university that they will reinstate you. Short period you have to forego. It is
more than
less than 3 years. It is about 2.5.
2.5 years.
Something you have to give up. Otherwise, how long you will fight this battle? Life is not the time for fighting the battle.
What I humbly submit is that, my lord, for the allegations made in the memorandum of charges, my lord.
How that will go?
My lord, I do not dispute that, my lord.
Yeah.
The allegation was that I did not accept the charge of the head of the department, my lord. For that, they have compulsory retired me, which is grossly disproportionate to the allegation.
Instead of that, your case is, it is grossly disproportionate. Means it is a guilt, but it does not attract that kind of punishment.
That kind of.
Now they are saying, without guilt, you will be reinstated.
But once I give that undertaking, that further future claim is been taken away from me.
Why future?
Because what I humbly submit, the Honorable Single Judge has only directed to reinstate me in service.
Correct.
Regarding the salary part, that part has been silent.
Yes. So you will not be entitled to.
As per the judgment, I am not entitled to.
Very good. I got that.
But in future, I may raise a claim.
No,
that is subject to the.
Brother has shown a judgment of apex for where unless wages are awarded, there is no claim at all.
That I know. But
that's how I was under the impression. I read one judgment of Allah High Court. Howell's judgment, remember that. He said once reinstated, everything will follow. But apex court has not agreed with that. Now, instead of spending so much time, so much life in the corridor of the court, which is not a happy place to spend, not like a park, is it? It's better to go. Some give and take. Life depends upon compromising the competing interests.
And another, if only they agree to the paragraph 710 of.
Where is your client?
She's in home.
Where? Which place?
Sambalpur.
Sambalpur. All right. We'll make the court order saying that you will not be. Anyway, that has not been given to you.
That has not been given.
Given to you. But so you should not hold any guilt at all against her.
No, guilt at all.
Otherwise, we direct you to pay.
I'll put that letter before your lordship.
Give that letter.
Your lordship can't have a passover. One.
Passover.
Okay.
Yes. In the meanwhile, speak to your client also. judges are saying like this, just consider that, then we can make an order.
Obviously.
Item 2.
Now, is it like this? Now you will reinstate, means the order of the learned single judge will remain intact. You will reinstate.
I have to take instruction.
No, you said that.
I will reinstate subject to the condition which has been put by the university.
That's what condition means. That she should come from
I'll
the third
place
floor.
that letter before your lordship. You will thank me.
You bring that. Otherwise, we'll hear and decide them. We're not going to adjourn. Yeah.
Item 2.
Item 2, it's a matter, my lord. Your lordship, earlier, a batch of case was decided by your lordships in that police matter where they have not submitted their property statement. That
Who appears for the other side?
decided, my lord. Your lordship have decided.
That's what. Who appears for the other side? First time it has come.
First time it has come.
Is there in our rules, can we direct notice to the advocate who appeared before the single judge? Is there such a rule? I believe there is such a rule.
Notice has to go. Notice has to go.
Issue emergent notice, returnable within 10 days. Yes.
Item 3.
No. Item 3, please, my lords.
Huh?
3 minutes. Lords, this is a contempt application of non-compliance of
Contempt application. We had received some instructions, my lord. That it is under
18/12/2024 is the order.
Yes.
Question of instruction, only compliance. But in the order.
My lords, order was to my lords consider my representation for revised scale of pay. My lords, the present petitioner was
Issue police notice, the standard of police notice is with the threat note, that notice, and police notice. To the witness. Yes.
Item 4.
2017 matters. Yes, Mr.
So your lordship, this last order, because the petitioner's counsel, earlier counsel had expired.
First,
So the notice would have gone from the registry, but
what happened to court notice?
no, unfortunately in the order, it has been reflected that requisites have to be filed and all. So it's not very clear, but actually it should be by the registry
They should
itself.
also set up court. Counsel on record is reported to have died. First off, registry to issue emergent notice by way of notice. Returnable within 2 weeks, since matter is very old.
Item 5.
Yeah, the batch of cases were listed. So for the state is the appellate.
Yeah.
On 2/2, 2026. In fact, there are 2 types of cases. One is retired, the other one is not retired. I am coming under the category of not retired. And your lordship passed orders in one of such cases. Very same day, your lordship passed orders in a case like me, in the WA number 2430 of 2024. Page 17. I have given that list also to people. 2430 of 2024. My case is exactly same. But my case has been decided Annexure A. And I have an annex.
One day.
Want. Only this is the order you also passed in other case, which will be covered. Same day, same day.
Actually, this is also available in page 90. Page 90. Judgment and covered.
Actually, I have also annexed that.
2 set of judgments are there.
Right. Annex 2 page 19 we are covered by that. Annexure C page 19.
Further dates are covered by that.
That is in 19. That judgment is also appended.
That is only that question.
Right.
Whether the continuance, these persons are continuing. They are in supernumerary post is to be created. That is
They were worse. They are far better now.
exactly. That is covered by the page 19.
Can you also look to page 19? The judgment I have given.
You have been absolved.
No.
Not at all, sorry.
Continuing as work charge.
They are continuing
As work charge.
and you have not retired. You are
No, not that. That's the only difference. Page 19 that judgment.
Anyway, triple 1-2.
Page 19 of the I.
The state and its official or in this infra court appeal. They intend to lay a challenge to a learned single judge's order dated 21 January 2026.
19.
19.
Go to that order.
19.
Impugned order.
19.424. Order is at Annexure A, page 8.
19. Correspondent employees WPC OAC number 4149 of 2016 having been favored.
Yes.
Relief has been afforded by the learned single judge in the following knowledge. Go to the last paragraph and that's what is there.
Page 43. 6.7 and 6.8.
First two. Having heard Learned Counsel, Learned ET appearing for the opponent's state, and Learned Senior Advocate, Sri so appearing for the advocate on record, we are of the considered opinion that the subject matter of this appeal is absolutely similar to the one in writ appeal number 2430 of 2024 between the state of Odisha and another versus Kishore Chandra Bhuyan.
In the main case is 1222 of 2025, page 19.
Page 19 of the idea.
The writ appeal in writ appeal number 1222 of 2025 between state and another others versus others versus Ranjan Kumar Rao. Heard in the discord of by discord wide discord or
Yes, yes.
Discord?
This
This is the principal
Yes,
decision.
That's what.
The
main judgment.
That is
State of Odisha. Sunny bus order to keep up in the.
Yes, you also refer to this.
Same order to be taken. We will not see this. Same order to be taken. Right. That only this will change. So the order will the date. And person will be the change.
Two, three से चाहिए पहले 2, 3 of that.
Your order rejecting that application, what is that, 13 to 2024?
No, Your Lordship.
That is date? You correct this and you correct this.
That one,
You
better,
correct
better. Because this one has to be changed.
In that case, the representation was rejected in the case of
word.
You remember, my Lord.
Identical thing, na?
Factual aspect of.
Oh. You can rectify that. Yes, that was.
Item 1.
That I have the letter of
University. Have you shared a copy with your friend?
yes, Lord, I will share. I will share my copy.
Give that.
Achhi, good. Yesterday night I got into my email.
You are in the official residence.
Yes, my lord. Official.
You are in the, that,
I
for
was,
that you have to make payment, na?
for that I will make payment. I have no date.
What is that second condition?
The second condition, she will give an undertaking not to reject any form of, because the past conduct your lordship has mentioned, the university has mentioned everything. That is,
First year law student would have written this memo far better than what it is now. That university has written on this.
there is false criminal allegation against the.
Now there is you have suffered an order. So instead of that
An order
being
that is-
confirmed, we are of the view that it should be confirmed prima facie. So we will argue.
Yes.
But what now you have come out with this fair proposal, you give it. The only thing is you make it this way. That she shall maintain discipline, shall not resort to any untoward incidents. That way. Not so many
That's what-
adjectives, adverbs and.
And he has to submit the annual performance appraisal report. He is not submitting.
He will submit it also. Okay, where have you written that?
Yes, Mr. I said. In the second concern,
Third.
shall give an order not to resort to any form of defiance.
That naturally she has to
Discipline in international disturbance.
No, even if we dismiss the appeal, also she has to do that. Is another thing.
Yes.
We'll make it complete.
Submit her
What do you say?
annual performance appraisal report.
Third. What do you feel?
Important
Copy has been some
Why
kind.
why are you not giving the copy to him?
Yes, Mr.
What kind of a lawyer you are? Why we don't like this?
No, sorry, Lord, I have lost.
We don't know all that. You give it
Email to them.
email or e-female, we don't know. If you want to read something to the court, you have to share that.
Yes,
with
yes,
others.
sir.
How they should defend.
Yes, sir.
Yes. What do you say, brother?
So far as the period of
For that you will not get. Even otherwise you are not getting because the order does not say.
my lord, what I humbly submit, sir. For that
And will nationally regularize this.
for that period, the salary portion, there is no
No order.
direction to the
Therefore,
judgment.
even if their appeal is dismissed, that
They will not-
that order will remain.
That order will remain.
Therefore,
But
what
what
they
I
have
hum-
written is innocuous.
What I humbly said, that prayer also I have not made in the present petition, my lord. That is subject to the. But what if I will give that undertaking now? I will follow my right to claim, my lord.
You cannot claim even this. It is not given by the single judge.
It is not given. But
You can't thereafter, you cannot raise the voice.
even if I
It is not given, we are not giving. You want to
that
get
I
beyond this.
that I humbly submit. Sir.
You are
That
not
I
in their appeal. No?
yes, ma'am. What I humbly submit. May kind of
No.
taken from me.
No, we curtail that right. Even otherwise, we will make it very clear. Because of the apex court issue.
Because I have had a phone call conversation with the respondent, my lord. He has
You will
stated
tell them
that for that period she has obtained much hand loans for her sustainability
Therefore,
and
university issue too.
You also
But
see
what
the
has
conduct of the lecturer.
well, she's a
She
lecturer.
has already been stated once.
No, my
Right,
lord.
that-
No, my lord.
Yeah, it is written now.
It is
No,
written.
she has not been
Not suspended.
She was suspended.
Reinstated. Some criminal allegation.
My lord, what has happened is that during that relevant period of time, the incumbency of person holding the post of the minister.
Are you agreeable with this proposal or not?
My lord, my humble sir, that it's the
Let
respondent.
me stay. Yes.
My lord,
Next.
may kindly.
No, next.
My lord, may kindly be.
Next.
My lord, I beg apology, my lord.
Wasting time of that.
My lord, I beg apology. My lord.
Your advocacy skill is not up to them.
My lord, I beg apology.
Even if he fails, you will not. That also you do not understand.
But I understand, but
First student to understand.
but
our
I
skill.
understand, but my lord, may pass.
You can't understand. You have to tone down the first part here. Otherwise, you would be casting aspersions on the lady. The first part you are saying you have many things, you waged war against
No,
the
I am only for your lordship's appraisal we have written.
that first part will remove. The second condition part will keep it as it is.
No, so far as this.
First part this is more heinous than what the allegations were against her.
No, so far
Even
payment of
First part,
salary is
lordship
concept.
means first part is in view of nature, extent, and this one.
That one. Considering all
Yes,
these,
yes.
That-
Only lordship will mention the
Only these
conditions.
two.
Conditions.
we'll say that way. This intra-court appeal by the university seeks to lay a challenge to a learned single justice order dated 14/5/2025, whereby respondent employees WPC number 34700 of 2023 having been favored by the following relief has been accorded to her. Next one. After service of duties, the respondent employee has entered appearance to her counsel.
Through cabinet.
My lord, through cabinet I had.
To KVA. On KVA. And he fervently opposed the resisted the appeal. First off, on the previous day, we had asked the parties to work out some kind of amicable settlement. First off, today learned panel appearing for the appellant has come out with a proposal. Wide letter dated 8 March 2026. Offering to reinstate the respondent employee sans financial benefits like back wages, etc. First off, he also tells that the employee should maintain good demeanor after reinstatement so that the peace and tranquility in the campus is maintained in the interest of the teachers and the taught. First off. Further, he adds that the employee has to submit all her pending annual performance appraisal reports, APAR. Yes. First off. With this proposal, the council appearing for the respondent agrees on instruction of our We also note that learned single judge has not awarded back wages. And therefore, even if the appeal is were to be dismissed, the respondent employee would not have gained it. Appellant cannot, full stop, appellant cannot be worse off in his appeal. The normal position of law. First off. Next paragraph. The above circumstances, we make the following arguments. First off, the appeal is disposed of. The respondent employee will be reinstated as directed by the learned single judge, but sans back wages. First off, the respondent shall maintain good demeanor, conduct, in service, without giving any room for any type of complaints or allegations. First off. Further, she shall submit the pending APRs within 3 months. We have to give 3 months, within 3 months. For the consideration of the respondent employer, appellant employer. First off, ordered accordingly and it appeal is disposed of.
Another humble submission is that in the paragraph 7.10 of the judgment, the Honorable Single Judge has directed that the respondent will take over the charge of the HOD as and when the documents are being regularized and being handed over to her. That portion may be.
We are not
remain
going
intact.
to hand over the.
They are not challenging that.
In future,
Another person has already hold.
in future, whenever
In respect of all other things out of the learned single judge, they may say that. Next.
Item 6.
Similar last occasion, those similar matters. I will defer to next that Hemant Chotra and Sarath Parid. But here notice was issued. For donation of delay, 10,000 was directed to make deposit. We have deposited the same.
Right now. Why the last order? Why the order dated 20 February 2026, we had said that first off. In terms of the said order, learned PG, Mr. Mohanty submits that a sum of rupees 10,000 has been credited in the registry. When you have done that?
7-3.
Oh, in time.
This is a slip, my lord. It can be taken.
He waves the credit slip in the court. No, it's not necessary. No reason to doubt the liars. First one. Next paragraph. Notices to go.
Yes, my lord.
Issue emergent notice. along with a copy of its order.
Last date notice was issued, subject to that, to deposit this one.
Subject to deposit.
And 22 my lords directed the emergency notice.
Process the notice.
Processed.
Fine. Next.
Item 7.
My lords, on behalf of my learned
Sub
speaker, I
item
am
also same. Sub item also same.
All subject same.
Same. Deposit also.
Yes.
Lords, item 7 on behalf of my learned senior. Lords, item 7 on behalf of my learned senior, praying for
One
court
time?
adjournment. Yes, my lords.
Whether the 2,500 is paid, my lord.
Paid. Call after 2 weeks.
Fix a date, short date, because I'm being
One
paid.
who is asking for time cannot ask for fixing the date.
Says that out of the station
Next time. Call after 3 weeks. The request of the network to the sharing from the respondent. Right. Okay.
Item 8.
Yes.
Interference from the lens mirrors.
Yes.
There is a delay of 82 days in between submitting also.
Yes.
Notice had gone. I think my friend has already.
Who appears for? You appear for which condom did it?
Yes, ma'am.
The intra-court appeal referred after booking a short delay of 82 days. First of an application 9 number 1645/2025, supported by affidavit accompanies the appeal memo. A plausible explanation has been offered, and therefore until any is condoned, and accordingly it is, application having been first. Anything?
Short point is, no, sir, I was selected and recruited and appointed as an Anganwadi worker. The applicant was selected and appointed Anganwadi
You were
worker.
selected when?
Yes, selected on, I was appointed on
When selected?
16/11/2024.
When were you appointed?
No, the selection was, notification was issued on 3/10, then
You joined on 16.
16/10,
No,
I
your
joined.
selection was on 310. 310/24.
Yes.
You joined
11 I was appointed. Read application was filed by the number 5 minutes with a prayer to consider giving her grace of 5 marks, 5% minutes on the basis of a government resolution, 40% disability.
40% disability. If it is 40% disability,
She will get
5%
5 marks extra.
wages she will get. It is due.
Yes, my lord.
Not out. I was not made a party. Even though she was at serial number 2 minutes, and I was at serial number 1, I was not made a party. The application was filed without making me a party, and the petition was disposed of. After disposal of the petition, immediately I was disengaged. Now she has been engaged. And my only question is, without opportunity of hearing to me, the writ application has been disposed of, so I may be given an opportunity of hearing, the matter may be remitted to the Honorable Singh.
Limited, will only this.
Then you
Why remittance? Unnecessarily wasting of the etc.
I rely upon the decision of the Honorable Supreme Court that if opportunity has been given, he has got a right to challenge that order in appeal with leave of
64 Supreme Court.
No, relying upon that, the recent Supreme Court decision, it's
Shivdev Singh, State of Punjab,
Constitution bench.
Constitution bench judgment.
that is full prayer now.
I'm also relying on the same judgment.
For
My lord, if he has not been a party, my lord, he has not been made a party before this.
You have to verify.
Then she has to
But
file
Apex Court has
separate
clarified that.
My lord,
Apex Court has clarified it in 2025, saying that review need not be filed. They can directly file the appeal itself
Appeal,
because review is a constraint in that part. That's the judgment you have brought now.
Yes,
25,
25 minutes, 25 judgment.
March of last day. You appear for whom?
my lord, for the
Other employee.
Yes, my lord.
My lord,
Who are the other parties?
My lords, kindly see the impugned order. My lords, it was only a case of remand.
Remand.
For reconsideration in because my lords,
But she has been sent out.
what happened? The person who was selected, she died. After that, the serial number 3 approached the court that my marks of 5 marks towards that disability was not given to me. The Honorable Court has reminded back.
No.
Consider.
That is not easy.
Yes, ma'am.
You are also a disability. Your case is also disability.
No,
My case is disability.
Her case is.
See,
government guidelines are not taken into
Mr. Samutrai, the client had secured 72 months.
And he was in number one.
Number two.
Number two. Yes.
And the person who stood third, she had secured 70 marks.
Respondent 5.
70. If 5 marks will be added, she will get 75. Only Honorable Court has directed to consider the committee to consider parties by in view of the
Correct.
notification.
Send her out.
Yes.
My
You should
lord,
have continued.
my lord,
Then you should have considered.
my
Then
lord,
after you could have done it.
there was an order that shall not be finalized without considering the
See, that
case.
time appointment was given.
It's not brought before the.
Correct, but he was not party.
My lord, your lordship, in any case, it will be considered by the committee.
No. He continued in office. She should be continued. And till a decision is taken pursuant to remand.
My lord.
That we do.
And one more thing,
I am continuing. By virtue of the-
What you are continuing? How is it there? She, 24, she has been continuing.
Well, she
Now
has-
because of the order of the learned single.
You have been
ousted.
disengaged.
She has been
Yes, but disengaged.
because after
Yes,
conclusion
always
time.
did.
What I humbly submit, my lords, your lordship may direct 15 days, within 15 days, the session committee may take a final decision. So that
instead of a decision interim order by your lordship in the division bench at the time of issuing notice, I have been disengaged, my lord.
Even despite order. Where is
If the lordship look at this order
Where is
dated,
the order?
your order dated 24/3/2025.
Why that despite order you will do all this?
Well, prior to that, respondent number 5 have already been engaged, my lord.
That you should have brought to the notice of the court. No, you also not said anything. You were the writ petitioner.
Yes, my lord.
All this mischief happened because of suppression of facts.
Yes.
Huh?
My lord, the learned single judge has never given a direction to appoint me, my lord.
See, the division-
The government circular. And as per the government circular, my lord, I am bound to get 5 marks. My
No,
additional
that's all right. That's
I'm
a
more
very
meritorious.
question is not there. Go to para 7 of the order of the coordinate bench. Mr. Behra.
my lord,
24/3/2020
List-
order.
list the appeal on.
No, come to the para 7. The rest of the things may not be necessary. List the appeal on so and so.
Consequential direction.
17/3/2025 will remain stayed till next date of hearing. Even after stay, you will disengage them. Who is that officer? Let him pay 50,000 rupees to her. Otherwise, nobody will cut their tail. They start wagging their tail too much. No respect for the division bench. Let alone single judge.
My lords,
My lord, they had filed a content petition for non-compliance, which was dropped, my lord.
Who will take action? It is dropped does not mean there was no order. It is dropped for so many reasons. Contempt is dropped because for want of ill will, etc. But order as such will remain.
So prior to that, my lord, I have already been engaged, my lord.
That makes no sense.
And I am more meritorious, my lord.
That the party authority has to decide after remand.
No, you were given appointment prior to this order of this court. Coordinate bench.
Yes, my lord.
Even then,
Yes, my lord.
But there we have been asked to not to give
that you should not have been given that Chamundi mopeds, where interim order is passed. The authority should implement the order and send other people out.
Yes.
Mr. Behra, we are imposing 50,000
my lords, let me take instruction whether.
on this matter tomorrow.
My lord,
Explain as to day after. Explain as to why the jurisdictional authority, despite interim order dated 24/3/2025 granted by the coordinate bench, has disengaged services of the appellate hearing. First off, the authority shall appear before the court day after tomorrow or day after. Okay? to show cause as to why heavy cost should not be levied. Yes.
Item 9.
In the meanwhile, however, if you engage,
My lords, will disengage everybody. Let the committee take a fresh decision. Your lordship may direct that.
court order has to be obeyed. Obeying the court order is the requirement of law. Yes, that's the requirement of law. You have seen what Seneca had said, where he directed X should be hanged for killing Y. And when he was about to be hanged, the person who is said to have been murdered came on a horseback from the other side.
Yes.
That executioner took X, Y, and this person also, all the three, to the king, saying that you had ordered for execution of this person, innocent man, for killing Y. Y is alive. Then he said all the three should be executed. Because you violated the order of the court, king's court. Therefore, you should be hanged for it. Then why, who is responsible for allegedly killing another person? He should be hanged. Other person is a cause of death of these two persons. Therefore, he also should be hanged. Same will happen here. Otherwise, the rule of law will not remain.
That's what you're saying.
Yes. You keep that officer present before the law. However, in the meanwhile, if the assignment is given to the appellant hearing in terms of the interim order, his presence shall not be necessary. Yes, so then order immediately.
I will be nowhere.
Carbon copy of the order shall be. Oh, you will be nowhere.
Because I am no meritorious pilot. You have not considered the government guidelines while selecting me.
Next.
Item 9.
Comply will
Item 9 is a batch of matters writ appeal filed by the state.
Yeah.
Where the state has challenged the honorable single judge order.
Covered by judgment.
covered with it.
No, that is an innocuous order. In fact, my lordship, without recording my constitutional lordship, we are going to comply with the order of the honorable single judge. Yeah. Because that is the 42, page 42, lordship, see. Consider the case of the petitioner in the light of the Pradeep Panigrahi case.
Correct.
So that we will, and if there is no other.
Then why have you filed the appeal?
My lord.
If you are to comply, why have you filed the appeal?
No. On the presumption that, my lord, there are some arguable points. In fact, I am not pressing that.
If you are arguable points, you argue, we'll consider. No, we are here to consider. But thing is, where unworthy appeal is filed, a citizen is drawn to the court, they have added to the pendency of litigation. Then that will not go unscathed.
But
for that, heavy costs will be.
No, there are grounds we have taken.
We'll consider.
Grounds we have taken that the work charge employee are to be regulated by a circular which was existing.
Mr. Panda,
my lord,
you know our nature. Instead of suffering the heavy costs, you have seen what the Apex Court said on Friday against the
therefore, I am saying, my lord, that we will comply, my lord, because I am not pressing them.
They are saying they will come to
unnecessary. I am not
do that.
Therefore, I am saying.
Live law has
at the first instance, I submitted before
government.
At the first instance, I submitted because now the law has been settled.
In all these matters, you say still you want to argue. Learned AG Mr. Panda, having argued the matter at length, now very fairly submits that the order of the learned single judge will be given effect to, and it has only directed consideration of the case.
In the light of the Pradeep Panigrahi case.
Pradeep Panigrahi is the division bench.
Yes.
No, Pradeep Panigrahi case was
Supreme Court is confirmed.
Decision in Pradeep Kumar Panigrahi.
And Lordship Pradhan also.
Orissa, no, where is that government citation? Pradeep Kumar Panigrahi versus State of Orissa and others. WPC number 3771 of 2020. Decided on 3/2/2021. Oh, it is not WPC, it is a division bench only, not Supreme Court.
No, Supreme Court has got to Supreme Court dismissed.
We are told at the bar that this decision on being challenged by the Apex Court, has been affirmed and thus has attained finality. In SLP number?
I'm giving it, I'll give in a slip to I'll give in a slip within 1 minute.
Right. In view of the above, nothing waste participation in these appeals, and accordingly they are disposed of. Cost having meetings. Yes. Yes, all matters disposed of.
Item 10.
Para 6, in para 6, that SLP number has been given by judgment para 6.
Judgment is the
Just show that properly drafted. Yes.
My lord, this is also an appeal by the same.
Within what time you are fixing the date? Within what period?
8 weeks.
The orders of the learned single judge shall be implemented within an outer limit of 8 weeks. First up, it is open to the decision maker to solicit any information or documents from the side of employees. However, subject to the rider that in that case, delay shall not be.
I draw your lordship's attention to page 38, para 6.1.
Which one?
The impugned judgment. The learned single judge, where the direction has been to consider to do the needful in terms of letter dated so and so issued by the state police headquarters by Annex 1.
Even those appeals, why the state is filing appeal?
Sorry, my lord, I'm sorry.
What is this? You should advise your client. State thinks that in every matter appeal should be filed. That is not the law.
We'll consider.
The state and its officials are in this court appeal. First off, they call it question. The order of the learned single judge dated 20 September 2025, whereby, which is this WP?
WP will not.
WP number?
26522.
26522
by 2025.
Having been favored, the following relief has been accorded to the respondent's employee. First up, next paragraph. Having heard learned counsel for the learned AGA appearing for the appellant state and its officials, and having perused the appeal papers, we decline indulgence in the matter in as much as the direction in the impugned order is only to consider the case in the light of that matrix and the law applicable. Ordinarily, such orders are not appealable, particularly by way of intra-court appeals. Next paragraph. In the above circumstances, the appeal being unworthy of merits is liable to be rejected in limine, and accordingly it is.
Personally, lordship, I also kindly add one thing, that we will give opportunity of hearing to the petitioner.
The impugned order of the learned single judge shall be implemented within an outer limit of 8 weeks.
3 months. It will take personal hearing.
Personal hearing to all stakeholders, including the respondent hearing. First off, it is also open to the appellants to solicit any information or document from the stakeholders if need be. Great. All questions. Yes, next.
Item 11.
Yeah. Yes, sir.
This was that matter which we are arguing, that everything was remanded by Supreme Court to be heard, and but we have got this by the single judge is also a further remand order. And I think we have.
Once it is remanded to the division bench, is it open to the division bench to remand it to the single judge? Is it that way? No.
No. Supreme Court said that let the single judge hear everything. But the single judge, instead of hearing, has remanded back it further to the Director of Education. That matter on twofold grounds, that whether I was really appointed or not, which in fact last time we had satisfied your lordship that there were enough of materials before the single judge and in fact the college had accepted that yes, she was working, she was appointed. But the second issue which we were stuck over there was this, that on the date on which the cause of action was, the Director of Education did not have the jurisdiction because the college was a private college, private unrecognized college. But by the time we had approached the writ court and the writ court disposed our matter and said that you go and approach the appropriate authority, the Director of Higher Education had already got the jurisdiction to hear issues of that particular college because it had become private recognized college.
Let me give the foundational facts.
Lordships, we had given a date chart of
Date chart you have given.
I'm giving it again. Again, we'll give it again. I think we'll take them to the Supreme. If your Lordships, should I take your Lordships first to the Supreme Court?
Just date chart, just explain to us.
Your Lordships, it is in 1993 that Saraswati Sanskrit Mahavidyalaya was established with Upashastri classes, which is basically +2 classes. And your Lordships, on 10/8/1993, Smitha Swine, who is the appellant here, was appointed as a lecturer in Odia at that very college. Initially, the college was established with +2 Sanskrit and with optional subjects like English, Odia, and history. Then, your Lordships, we send our application for recognition on 11/4/1994 in that same very application inspection report for provisional permission. And in this inspection report also, my name appears. In 1995, your Lordships, the +3 classes opened. And when +3 classes open, then you are allowed to have a full-time lecturer. And I was the only person who was working then.
Yeah.
1997, a person called Hare Krishna Swine got appointed. And
No correct
immediately,
date.
your Lordships, not no exact date. I don't have. We don't have.
Yeah.
And 1998, what happens is I am prevented from discharging my duty.
So OJC.
Yes, your Lord. Now this OJC is pending. While it is pending, your Lordships, we get our temporary recognition and a permanent recognition in 2009.
For both the courses.
Yes, for the entire college. And your Lordships, 30/3/2011, a person called Madhav Chandra Malik, which Mr. Das is representing, he seems to have been appointed, which of course again is debatable college. But he is anyways is there. And Madhav Chandra Malik has also not produced any letter showing about his appointment. Then in 2015, that is 4/5, the OJC gets disposed of. It's withdrawn with the liberty to approach the appellate authority.
Appellate authority is under the government order.
Yes, because by that time I have become recognized.
So that authority had jurisdiction.
On the date of the disposal of the writ. Yes. Then accordingly, I approach, and on 26/3/2018, again the status of this college, it is not only private, recognized, now aided. And on 11/7/2018, the director passes an order in our favor. What the director finds is that on 11/4/1994, the inspection, that report you had said, your name of Smitha Swine's name was appearing.
Yeah.
And even the government, even the college accepts the position. So the fact of my appointment and continuation.
Who Malik challenged it?
No, Malik has not come into the picture.
No, 28/2018.
Yes.
Challenged that order.
What Madhav Chandra Malik did meanwhile, he went and he filed a case in the tribunal claiming certain financial benefits.
No, he filed he challenged the order of the appellate authority, WPC.
Yes. Yes. He challenged this director's order.
Yeah.
And that director order on the ground that you did not make me a party.
Yeah.
However, the cause of action when it arose and everything, he was not even there in the picture.
He was appointed during the pendency. So this pendant applies, and therefore he cannot say that
was because Hare Krishna Swine probably came in, because they could have only kept one person. They got Hare Krishna Swine and did not allow me to function without giving a formal order of termination. Did not allow me to function. But Hare Krishna Swine was also on his way to be retired. So that's why the Madhav Chandra Malik said that if I have to somehow block this person, in order to get all the benefits of that one single post, which I get to understand must have been the thinking process. Now, which is what happens is this particular, I also file a counter affidavit, and a counter affidavit is also filed by the college.
Institution and you sent together.
Yes, today, yes.
Even today.
Even today.
Before the appellate authority?
Yes, Your Lordship, because before the appellate authority, only the government produced a document showing that yes, she was working. They did not dispute my appointment. Now, Your Lordship, this writ comes to be even before the single bench. Also, the college supported me on 10/4/2019. The case of Madhav Chandra Malik was actually dismissed on this ground that both of you really don't have a list. She was appointed prior to you, and there was Hare Krishna. So they kind of.
You were a respondent there. Your opponent.
Yes, I was the opposite. Because he was challenging that order, which was beneficial to him. But, Your Lordships, on 6/8/2019, a writ appeal was filed on a very different ground. A ground that the director did not have the power to pass that order. They were challenging that.
On that ground.
On that ground.
That ground was entertained when they had no stake at all.
But I wasn't the counsel there, so not really. And yeah, we also on that ground itself, single bench order goes. Review also.
They said that Malika was appointed. Both they were appointed to different posts.
Yes. They said that you were appointed. I was first appointee. I'm a different post. You have come as a third person. You are appointed a different post. Because even if I am kept aside, before him there was another person. So he was at best a second post holder. Your Lordships, what happens is during this review petition, which we had filed against the writ appeals order, Madhav Chandra Malik files up application before the Education Tribunal for some financial benefit. Grant in aid, basically.
When you had filed it, the review.
Review.
You filed it during the pendency of your review.
He filed it during the pendency.
Do you have the date on which he filed it?
8/2020.
Before the Educational Appellate Tribunal.
Now, Your Lordship,
not the competent authority. Is it the appellate tribunal which you are referring to?
It is an authority to decide these financial aspects when a college becomes an aided college.
Is it established under circular number 13585?
No. Under section 24B of the Act.
Of the Act itself.
There's a provision there. There's an Act. Your Lordship, thereafter my review gets dismissed and I am before the Apex Court by 5/1/2023.
And
now, during the pendency of the SLP, the tribunal passes an order in favor of Malik. And then Supreme Court takes a view that I'm setting aside all the orders, the single bench order, the division bench order. You go back to the single bench. All of you raise everything there.
Why Apex Court referred to Swapna Mohanty? Come to your page number 6.
So because that's the judgment of first post, second post. That first post, second post. So they refer to
2017, 621.
Is the judgment?
Do you have that judgment? Just we want to
be searching. We already have the
If they refer to this. If they have referred to that, then the impression is post which they occupied are different from each other.
Yes.
If that is so, where is the conflict?
No, now the problem is what the single judge did is after everything was remanded, single judge heard the FAO because we challenged that tribunal's order. We individually, Smitanjali also challenged that tribunal's order and we filed an FAO. Yes, from the tribunal, we had challenged, we filed an FAO and the writ which was restored again for hearing was also heard together before the single bench.
Both they were heard together.
Yes. And both of us were remanded back.
Means one which was remanded by the apex court and the one where the appellate order of the tribunal was challenged on 24B. Both they were clubbed and then they were heard together.
Heard together. But first is the
Remanded for the purpose of entertaining jurisdiction.
it's to determine whether the director had the jurisdiction and whether I really had been appointed or not. Because the single judge gave passed an order saying that there is you have not produced the appointment order, but there was enough material before the single judge regarding my appointment. That was the first ground of our challenge before the writ of appeal.
There is one judgment of the apex court where a particular statutory authority did not have power to decide the matter on merit on a particular day. But subsequently, it gets power because of amendment, etc. How that should be treated? There is such a judgment by three-judge bench. Judgment. Do you have my notes? Notes remand management. No, order to make. There is one.
We have got one judgment.
What it says?
1975 to SEC.
Page 61. As on the date the learned single is remanded, whether the authority has got power?
No.
That way it was not
Gets the power.
Then it was not recognized.
But when the writ petition got disposed of,
Then it had come.
the director had the power.
This petition was disposed of.
2015. So my approach.
By virtue of that circular.
Yes. Circular to copy the it's there.
Page 140.
Number 13585 of
Page 140.
27383.
Yes,
No.
that's there. Yeah, at page
No, may
140
not.
of the brief.
May not. When with effect from which date the jurisdiction is extended?
Circular date is 1983.
1983. I tried to say that it's brought to the notice of the comment.
May not be 83.
1983, Your Lordship.
No, your story begins with 93.
93. This is from 1983.
1983.
But my story does begin with 1993, but unfortunately, back in the High Court appointment, it wasn't recognized.
Therefore, he had no jurisdiction.
That's the case of the other side. They said that you should count it from date of cause of action, but we are saying that we will count it from the date when we actually approached for simple reason, for on the ground of this understanding, that is only a forum change.
Page 16.
That judgment.
Very well noted. Page 16.
Your Lordship, that judgment next.
What does it take?
That's at page 61, Your Lordships. Para 5 of that judgment, Your Lordships will find that relevant portion at page 61 of the note. May I read para 5?
About 5.
Right.
Plain language.
On the plain language of section 11A and 110A and 110(5), there should be no difficulty in taking that view that the change in law was merely a change of forum, a change of adjectival and procedural law, and not a substantive law. It is well established proposition that such a change of law operates retrospectively, and the person has to go to the new forum, even if his cause of action, right of action accrues prior to the change of forum. He will have a vested right of action, but not a vested right of forum. If by express word the new forum is made available only to cause of action arising after the creation of the forum, then the retrospective operation of law is taken away. Now, Your Lordship, this was existing from 1983.
83 means very change of law.
Yes, Your Lordship, but
There is no change of law.
there was no change of that position. But when the nature of the
Facts change.
yes, the nature actually
Because
everything-
recognition is obtained.
yes, the change in the institution's nature actually gets the application of law.
Therefore, this judgment will not apply. This judgment says,
yes,
which 1861 the House of Lords said, where substantive law is amended, it is prospective in operation, otherwise indicated.
yes.
where procedural law is amended, it is with retrospective, contra is indicated.
Yes, yes.
That has been reflected.
Yes, that's
Where is
that.
the change of?
Now, Your Lordship, yes.
Fact is changed in the sense, there is nova causa intravenous, in the sense, the recognition is obtained.
Yes, Your
That's
Lordship.
all. It's not change of.
But the whole thing is, Your Lordships, the history of every institution, this private institution has always been like that. That, they will come, then there's a recognition, and then there is
But this decision will not help you, because not a case of change of law.
I will agree, Your Lordship, this is not strictly a change of law. It's an applicability of an existing
what.
law because of a change of a particular fact.
Change of fact matrix is one thing. Change of law is another.
Yes, yeah, I will agree. This is the limitation of this judgment.
Therefore, that will not help you.
But Your Lordships,
You bet that judgment. You don't
yes,
have
Your
to take all the-
Lordship. Your Lordships had asked us to actually, that note has on
No,
that.
because we
petrol
asked you
also.
because under the impression there was change of law.
Yes,
But this is not a case of change of law.
yes, that's the
Therefore,
limitation in my argument. I cannot.
It's only the fact being not noticed like this it is. Or a fact coming into existence. Nova causa it is because, to some extent, because recognition is obtained. And recognition is a sine qua non for jurisdiction by the authority.
Yes.
Therefore, that proposition.
And the issue is here, Your Lordships, suppose even we take the case of the other side
No,
also.
is it your case that it's not a case for remand at all?
I think it's not a case of remand
Because he himself, by that time also he had.
so many litigation, Your Lordships, I think I'm left with how many years of service? If I do get back some 2-3 years of service. And if the issue is only this, that whether I was working and whether the principles of natural justice or any semblance of procedure was followed to throw me out of the college. The fact remains is the director has given enough of information that yes, I was appointed. The college also admits to this fact. I think this is not dispute as far as any one of us is concerned. So all that.
Who appears for the other side?
The college, I think Mr. Mahathi appears.
Das appears for Malik.
And Malik, who has been challenging, was the third person to enter.
Mr. Malik is also.
And for the
Management.
we have tried a counter in the data application supporting it, not that is a page.
You support the case of the appellant, employee.
And in fact, because there is no other alternative, because without the director, we also submitted notes and records that he was working
during the relevant period. So vacancy was not there. And to appoint another person.
He came much later. Then one Hare Krishna Shripad, another person. For that I was prevented. Then that Hare Krishna Shripad retired. He joined
that vacancy.
No, he is claiming the post of Odia lecturer. And that is altogether different post.
Yeah.
That is what our stand is, not your lordship kindly see.
Mr. Murthy, do you want to add anything to what Madam Pami has argued?
Except that your lordship was referring to a decision. That's what happens in this case.
No, that may not be because there is no change of law as such. That decision, para 5.
No, your lordship, this decision will not help.
Will not apply.
But your lordship was just told that there is a always decision.
There is a constitution judgment which says where the jurisdiction is acquired. But even that will not apply because that was a change of law. Even there, it was a change of law. I have got in my notes, I have got that judgment, in fact. I may take some time to lay my hands on that. That's different.
Yeah,
but there is such a law. Even in the CPC, where jurisdiction, monetary jurisdiction was prescribed, decree came to be challenged on the ground that he did not have monetary jurisdiction.
Initially, supposing there is no jurisdiction. Then subsequently, during the pendency of the litigation,
if jurisdiction is acquired,
jurisdiction is acquired.
That is sufficient.
Then
That is, that's it in so many cases.
That's what.
Cases pending here are being transferred to that court because we lose jurisdiction, they assume. That another
NGT when came, if you just remember that NGT when came, all the matters from here went to there.
DRT also.
DRT, commercial court.
So many
The company tribunal also.
tribunals. Right. Yes, let us see what the opponent will say. Yes, please.
The short question is what just out from this, just for a repetition and for my sake, my lord, I will submit. Here is the case of my learned friend is that she says she was appointed sometime in 1993, 10/8/93. So it was not there. Court is disputed. So I am not there. Let us say 1993 was appointed, and she admits that she was terminated in 1998. But the fact remains from the record. The institution got reformation only from the session 2005-2006. Academic session has been defined on the statute. Academic session starts with 1st of June of that year. 2005-2006
to 31st of March of the succeeding.
May. So 31st of May.
1st
of June. So
31st.
So now the permission is granted to the institution to establish for its establishment, which is a condition precedent in the statute. Only on 1/6/2005. 2005-6 session, it starts with 1/5/2005, 1/6/2005, 1st of June. So the institution came into existence with the prior permission of the authorities only from 1/5/2006. So what is it an appointment in the eye of law, first of all? Because the institution was not in a position to have it, put into earth. Recognition is a subsequent affair under section 6.
In your statute, the 69 Act.
Yes.
Under 69 Act, permission for establishment of the
institution is a condition precedent.
Then recognition is what?
Subsequent. Recognition is a subsequent affair. After you are established in an institution with the permission.
What is establishing the institution?
Well, so the statute says under section 5 that if a body of person or a person wanted to have an institution, any type of institution, primary, secondary, high school, college, whatever it is, my lord, they have to make an application that prescribed for.
No, what is meant by establishing an institution?
Establishing, opening an institution.
Means what?
I want to
changing the words.
No, I'm not. Shall I? So it will be better, my lord, if I read section 5.
Well,
better.
Get it.
Well, section 5.
So it is a permission, no much about that. But one matter which you had argued before us on a bench where I was there.
Which one?
No, on this Education Act.
Yes.
You and Mr. Lenka had argued that matter. No, except that I don't have much exposure to your 1969 Act.
Oh,
but I can understand.
Yes, why not? 123 page. 123 page. Kindly have a glance. Page 123. Bohil. 123, section 5. Permission.
For establishment
of educational institution. No private educational institution which require recognition shall be established except in accordance with the provision of this act on the rule made thereunder. Any person or body or person intending to establish a private education institution or opening higher classes, new stream, new optional subject, additional section, or increase in number of students to admitted introduce honors classes, new subject in a recognized private education institution or upgrade any such institution may make an application to the prescribed authority within such period and in such manner as may be prescribed for grant of permission thereafter, provided further all these things. Shall I read entirely? Thereafter appeal provision, everything is there.
The permission is
necessary. So but to open even any existing institution, if he wants to open a new stream, suppose it has science, now they want an art stream, they will also have an application. That is the requirement of law.
Which requires recognition.
Because
If it's acquired recognition as on that.
Yes,
then
yes. Permission is established. Here they have got the recognition. Here, after granting permission, they have made an application for recognition. And recognition was granted to this institution.
No, as on the two things.
Sir,
Law requires recognition.
my lord.
Therefore, permission is required.
My lord.
That is how section is structured.
Fine.
Is it your case that as on the date the institution was established, law required recognition?
If they, here in the fact is, the institution first you have to apply what is there in our statute is, you have to make an application.
No.
They will give you a permission.
Don't agree.
No, it is
Provided
recognition is sought for.
recognition is required.
Correct, my lord. Here the fact is
Yes,
that,
that recognition was required.
yes, they said that you have got the recognition. This
That's
is
another thing. As on the date, see, permission for establishing the institution is required if recognition is required. If recognition, because the requirement of recognition is inbuilt in the section itself. Class 1, subsection.
well, section 6 then. Let me clarify after reading out section 6.
Is it?
This is part of the recognition. This deals with section 6 and 6A. Let us have it first. Recognition of educational institution. An application for recognition of a private education institution shall be made to the prescribed authority or on or before the 30th November academic year of which the institution start functioning. This word start functioning. Provided that no application for recognition filed before commencement of the Odisha Education Amendment in 94 shall be rejected only on the ground it has not been filed within the date specified in the subsection. Academic year means 12 months from beginning of the 1st of June and ending in the 31st day, so and so, so and so. No private education institution shall be eligible to recognition unless it is established with prior permission under this act. Yes.
The whole sections are contravening each other. Here you say an institution for which recognition is a must. That cannot be established without permission.
But
here you say other side. Exactly the reverse. Which one is prior, which one is later? How to make it?
Well, this is sino-connot. This is intermingled. What happened? The next question is, we want to, this is beyond the statute, I'm saying the Boards Act. Suppose we are going for a high school. The students are admitted in a particular school to present themselves in the annual HSC examination, which is a recognized examination. For getting a recognition by presenting the students in that institution, they have to get, even such an institution, if you will conceive, as fall from my lord's mouth, that yes, even if you don't want a recognition, then you have to establish an institution. There is no bar for this. If I want to correctly, I don't want any recognition. I have understood in this way. I don't want any recognition. I have established an institution.
Not whether you want or you do not want is not the factor.
No, it is giving
what the law requires is the factor.
Yes.
Kindly see section 5 is structure.
Yes, yes.
See the language.
Yes. See, with that language, I'm the logical conclusion. I'm just giving a logical conclusion to this statute.
5 and 6 are cognate sections. Because they deal with one common subject. Permission and recognition. Permission is different, recognition is different. Otherwise, two words would not have been employed by the legislature. There is a presumption that legislature understands English. And when legislature uses two words, it uses with significance.
Yes.
Okay.
Yes.
Section 5 speaks of permission. Section 6 is recognition. But there is a hitch because first part of section 5 requires permission only if recognition is required, not otherwise. So part of 6 is ready to 5.
If before then, we have to read section 4 first. Because this section 4 kindly see very good. But it may give some light.
Yeah.
This chapter 2 deals with 4, 5, 6 and all these things. Establishment, management and control of educational institution. The heading.
Yeah.
Chapter 2. 4.
This is the amendment.
This is the amendment in 89. Because this 4, 5, 6, everything come in 1989. Prior to 15 of 1989, there was no concept of this permission, madam. This concept of permission come in 1989.
So 1983, this institution was...
No, 93. 93 she is saying, established in 2005-6. Much after that, right? Much after this amendment.
So post 1989 amendment.
This is 89. Amendment is 1989. Institution, according to her, it is 1993 is after that. So now,
Let us read 4.
the establishment recognition of education institutions. The state government may regulate the primary and other stage of education in government and private education institutions. The government shall take from time to time such steps as they may consider necessary for expedient for the purpose of providing facilities for general education, special education, technical and professional education, and for training of teachers. The state government may, for the purpose of providing such facilities, establish and maintain educational institutions. B. Permit any person or body of person to establish and maintain educational institution and recognize institution when so established in accordance with the provision of this Act.
Kindly come to B. Read it again.
Yes. Permit the state government
B is to the minor. B is interwoven in section 5.
Minor. Just I'm reading it.
4, 5, 6 are kindred provisions there. They treat the same subject.
Same chapter.
It gives power to the government to grant permission and to confer recognition.
Minor.
That is 4, 3, B.
Permit any person or body of persons to establish and maintain educational institutions and recognize such institutions. There is a word and.
Correct.
It has to be recognized.
Well,
subsequent section 6. Section 6.
Therefore, for establishing an educational institution, if you read 5, 2,
Mine.
5,
yes.
5.1 begins with the negative terminology. No educational institution shall be established. So it's a mandatory.
Except in accordance with the provision.
Therefore, it is mandatory.
Mandatory. Without a permission, you cannot have.
You cannot. Because it starts with the negative.
Yes. So,
it puts something more in that. No private education institution which requires recognition, though word require is there, yes, you have to add in that. There is a small mistake.
There is don't put it together to understand the purpose.
Yeah.
Legislative intention.
In other words, kindly see. 4, 3, B.
My lord.
Has to be read with the 5, 1. Has to be read with the 6,
6A. 6A have the condition.
6.1.
6A also there is another provision.
6 capital A.
A. That is conditions. What are the requirement for recognition?
That is condition for
conditions for. These are the criteria required formalities.
Now, what we want to know, any judge of this High Court has stated these sections?
I have to check up. Yes, the many cases decided.
Because it is not that for the
as I have of court, I am wrong to say, but as my knowledge goes, my lord, permission is a concept introduced to the statute. So therefore, every institution established, that is, I am saying I will check up, my lord. I will take my words to be final.
Why we say?
So I will go check up all this part. I'll come back with this judgment because many cases decide because this is a long way back. 89 amendment has come. The past decisions.
Kindly listen to. You have not seen all that. What jurists have said, like Aaron Barak, what they say is, whole of the act should be read first.
I know.
Okay. They don't say act. Whole of the statute should
has to be read.
Because statute may be contained in one chapter.
Yes.
Other chapter may not relate to us at all. Whole this chapter should be understood. We are not born with English. English is a borrowed language for us. So naturally, when states enact law, there are crudities in the text of the law. One section says like this, another section says something else. Then we cannot say this section is bad because it violates the other section. Because both the sections have arisen from common lawmaker. In such a situation, Aaron Barak says, it's a famous book, The Persuasive Theory of Interpretation, Mr. Panda. Aaron Barak, the Israeli Supreme Court's Chief Justice, this is a great scholar. He is considered to be pre-incarnate of Justice Oliver Wendell of US Supreme Court. He's a great scholar. He has written The Purposive Interpretation of Law, Judge in a Democracy, Dignity and Humanity. So many books he has written. One book which Apex Court has treated, even Honorable Justice Arade, in his G.P. Singh's interpretation of statutes, statutory interpretation. He has referred to Ehrak Barak. What he says is, when all these sections are incongruous, he uses the word incongruous because one section mutilates the other section. In such a way, the purposive and comprehensive interpretation has to be found. If necessary, by ignoring certain words in a provision and by introducing certain words which the legislature did not to other provisions
To give a complete meaning.
How any of the judges of this court,
But it is,
how they treated
it
this?
is, they have not have to come back. I have to come back because
Madam Swami, this is a question to you also.
Yes.
How various judges of this court, because this act came in the year 1969. Although 89
is the, there the disputes were.
89,
89
you were
no,
not
file.
lawyer at 89. You were very lawyer.
Yes. But no, I was not.
Therefore, there is some view available.
That is there.
Availably. The various other.
Instantly, I cannot say, but I have come across. I can
That you have
Yes,
reported on the place.
every
But
time we
there is a direct decision on the bereft of all this
you
section.
prepare your draft.
What
There
judgment?
is incongruity in the legislation.
What the division bench?
4 appears to be generic.
Yes,
5 appears to be specific. If generic, specific collide with each other, specific should override the generic.
for that particular situation.
it is,
That way. We are traveling from, first we gain entry to 4. From 4 we travel to 5. From 5 we travel to 6. That is how it happens in the interpretation of statute. Therefore, always the great scholars like Crawford, Crace, Sutherland, and even Maxwell, they say, read the entire statute first. Have a broad helicopter idea of a legislation. Then address specifics. That will make sense.
Yes.
We cannot do that. The very, very sectarian interpretation it will be a violation of the legislative intent itself.
I agree.
Therefore, do some research. I will also do.
Yes, ma'am.
When I say this,
Which will happen.
with an intent
Yes.
to do research. Hey, ಅದನ್ನೆಲ್ಲ ಮಾಡ್ಕೊಂಡು ಹೇಳ ಸಣ್ಣ ರೈಟ್ ಅಪ್ ಕೊಡು ಎಲ್ಲ ಮಾಡಲ್ಲ ಇದು ನೀನೇ ಮಾಡಬೇಕು.
We'll go through the
one of the judgment of this honorable
Don't
court.
do all that. See, we have
This is a division
let
method.
the broad the framework for this case.
All right.
You bring your note. You infuse your wisdom, your
Right.
expertise in this matter. How various courts, the coordinate courts of Calcutta, the education
Yes,
act is there in every
Yes,
state.
everywhere.
A little different depending upon the requirement of the reason. Bring comparative jurisprudence here. That will help you. Not reading sections and going like
the whole act and make an honest endeavor. Not that it has to be here or there. Honest endeavor.
honest endeavor, comprehensive endeavor.
Yes.
Then we will be able to do. Otherwise, it will be one more judgment. That will not end the litigation at all. Once for all, litigation should come to an end. That is a judgment.
My lord, the plain meaning of the reading of this language of section 5, permission is not mandatory unless recognition is sought for.
But 6 speaks something else. Why does it?
There is a lot of linguistic fluidity. There is lot with the due respect to the whoever lawmaker. There is a lot of linguistic fluidity in the text of section 456 that we could make out. Let us see how there are judgments by Lord Denning also. There is linguistic fluidity in the provisions of a statute, how it should be addressed. The All England Report 1948, All England reports. Just look into that. A judge cannot say, no, there is problem, section is not properly drafted, and therefore we can't grant the relief to Fami's client. That's not, we don't have such jurisdiction. Man has come here with some grievance. We have to treat. We have to treat this way or that way.
It has to be interpreted.
Interpreted. It's a matter of interpretation. Yes. Just look into some statute, the Sutherland on interpretation.
Yes,
Crawford on interpretation of that. Yes. Just look into this. Is not a new thing. For the first time, it is arising in Orissa High Court. Such a problems arose even in English courts, because more particularly Privy Council. Because Privy Council was exercising jurisdiction on several colonies. Colonies were not grasping the English language properly. Therefore, these problems arose. Such problems were there in Australia. Because Australia continued to be the colony of India for quite long, for many, many years. Even long. Yes, because Australian judgment. Yeah. Keeping it up. Good. For making research.
Yes, it will be.
Bring your notes. Yeah.
Item 12.
Can we treat it as certain part?
Yes.
Very good.
Das is this.
I don't think he will have any of
That's the.
Ask your senior whether it can be treated as part-heard, because they have spent a lot of time on this. Well, ask and come. After he comes, you draft it. After 2 weeks. Next.
Item 12.
Yes, Mr.
But here the petitioners have challenged the judgment passed by the Central Administrative Tribunal, wherein the only question is what is the cut-off date. Cut-off date for selection to a particular post. May I take a lordship to the artisan first, then the lordship may improve.
Give us the foundational facts.
Foundation.
Yes.
Well, the foundation of fact is that the advertisement was made, there is a post of GDC, that is direct recruitment post. Some posts were carved out of those posts for regular employees because of the stagnation in service and the continuous working for some years. There are no promotion avenue. Some posts are carved out of those direct recruitment posts. And advertisement also published for selection of those posts also. Those persons who are there in the lower group C to group D to group C. So what happened, my lord? The advertisement passed where the date, it was the age was fixed also. The age was also fixed. The age was fixed, and the persons who ultimately, when the result came, ultimately persons who we found the persons who have been appointed after the advertisement and before the last date of application, they have been selected. The persons who are appointed after the advertisement, before the date of selection, that within 1 month, those persons have been appointed, they have been selected. Those persons have been selected. So we challenge for the tribunal, saying that they are not eligible because they are not eligible because the cut-off date has been fixed to the date of application. So date of application they had not been appointed, so they are not eligible to be appointed.
Let us see the recruitment notification.
That's the reason why I'm
recruitment notification.
May kindly see advertisement that is at page 33.
That is advertisement.
Page 33.
2/11/2015.
Sorry, my lord.
2/11/2015.
Yes, my lord.
That's the next exam.
My lord, General Department Competitive Examination, GDC.
Lecture 1.
Lecture 1.
That is for the post of goods guard.
Goods guard. There are lots of applications are invited for
only
Second guard which for S.
Yes.
First is for goods guard. Second is S. But advertisement is for both is one.
It's the GDC, the General Department of Competitive Examination. That is the. I'll take a lordship to the first lordship. May kindly look at the page 35. What is this advertisement for? Para 14B. 15. GDC quota is earmarked out of direct recruitment candidates vacancies. The standard of examination is therefore similar to that conducted by RRB for open market candidates. So there were out of direct recruitment vacancies and para 16. Sorry, madam.
Railway recruitment board.
So, para 16, my lord, may kindly see what for the advertisement was made. Cadre controllers are requested to forward the GDC application liberally as it is an opportunity to the serving railway employees as the career advancement program. Effort should be made for wide publicity of the notification. So for this reason, the posts were carved out and the persons were there in the lower grade for a long time for their career advancement. This posts were carved out for them only. My lord, may kindly turn to
Appointment to those posts are done how?
By recruiter regular selection, my lord. They have to apply for the post. Selection process is same. Selection process is same. The direct recruitment selection process and the persons who will be promoted to that post, selection process is same. They did not. Selection process is
to appear in the written examination.
written exam, whatever.
So the promotees will also compete with the direct.
No, direct, but some posts are around. Posts are reserved for them.
Against their quota.
Against that. There are 100 posts are there, 25% reserved. So against 20, they will be eligible. Rest 70%, they will be in. My lord, may kindly see the zone of page 33, previous page.
33.
33, para 3.
Before advancing my thoughts, what I'm playing, can it be day after tomorrow?
One day after tomorrow.
No,
Next week we'll have that.
Next week.
Next week we'll have that.
Sir,
Can you have it next week?
No, yes, you can. Because it will take adjournment and several occasions.
Examination also doesn't want that. For two advertisement, two separate question.
No, this period this adjournment you are seeking for what purpose?
Yes.
So this is two things, kind of. One, they have participated.
No, that's argument.
There's
Now you are seeking adjournment.
But why I'm taking time, minor? There are two separate advantages, not a one advantage. First one is from this post of the boards one. Another one, second is on ASN.
Next week at the request of is final.
Yes.
Yes. Also please. Again, we will not give time.
Item 13.
Yes.
Pursuant to Lordship Direction, dated 10 to 26, the Lordship directed and filing affidavit. Copy short, my lord. Your Lordship directed the petitioner and both the parties. Petition is the first one.
Have you served copy on the other side?
Giving.
Person who there were two marriages.
My lord, the petitioner is the legally married first wife. Present petitioner
first wife.
And the Central Administrative Tribunal, my lord, without serving the copy, even though the present petition was made as opinion response number 4, the past the order.
Make use of your mind. Only your two words were heard by rest of the people. Yeah.
My lord, the response number, opinion number 4 in this writ application, file original application before the Central Administrative Tribunal, including me, the present petition as of 4.
Your OP number 4.
Before the tribunal.
Who had filed? Your client has filed OAS. OA number?
733 of 20.
Mine. And judgment was passed on 5/6/24.
1 second. Why you were before the tribunal?
Claiming,
madam, why your client was before the tribunal?
1 minute.
What was the complaint before the tribunal? What was your grievance?
Her grievance was to release pension in your favor. In your favor.
So that's why
Not stopped.
Pension was stopped or pension was not sanctioned?
not given to me.
Not sanctioned.
Yes. And she implemented the present petitioner as a respondent for
Though you have implemented as a party in the OA, you have not been served notice. That is your.
You were not served itself.
Short man.
No,
That's
this
No, that is his case.
My lord, this Hon'Ble Court directed on 10/9/24 order, your lordship kindly see.
10/9/24.
My lord.
10/9. 10/9.
10/9/24. Para 4 mile. Directed to Central Administrative Tribunal to produce the report.
The report has been.
That's all it is. Where is the proof that he was served, your complaint was served or not? Is there any material?
No material.
You were not served.
Therefore,
Someone
director.
also appeared for before.
No, provided if some notice is served, somebody will appear.
Notice alert issued, my lord.
Issued is when it was issued, when it was served.
Now I could not able to produce the
Records will come from the tribunal.
From the AG, office of the AG.
Office of
Accountant General.
Submitted both the courts on the behalf of our last order also directed that produce the documents.
Where is the report, brother? No, he is saying his client was not served.
Notice has not been served. That is the allegation.
That's the allegation.
Yes.
If that is the allegation, you have to show notice was served. Because otherwise you will lose the case. Section 10102 of Evidence Act. When a fact needs to be proved by a person, who should prove? Person who will lose the case, if not proved. He has to prove.
no.
Yeah, no, that is the point.
Sir,
that is the position.
My lord, kindly the additional affidavit filed on today, kindly come to page number 6, annex to 4 of that affidavit.
In your affidavit?
Yes, ma'am.
You have stated
number
service.
4. OP number 4.
Service you have said?
Yes, my lord, I have
No.
solved.
Just that's actually the question. Question here, the solve.
No.
Service, he is saying, I have not been served with the court notice. Behind me, all this has happened. Therefore, set aside order. Now, if you show, two options are available.
In the case, I will try to produce that record from verifying the cat. Yes, ma'am.
See, we have only one report from the Joint Registrar who has said that on 4/1/2024, as per records, notices were sent by speed post to all respondents, especially hide serial number such and such to respondent number 4. That's all. Whether it was sent.
Not sufficient. Not sufficient.
And nothing.
Not sufficient.
My lord, unless and until that speed post's notice not returned to the...
Who will hold it? How it is to be fixed then? The report doesn't speak about
Notice are not sufficient.
Thereafter they say that the meaning is something.
It deemed to be service because the notice not returned as unsolved.
No. Has it come? Eddie had returned.
Returned as unsolved, my lord.
Where is that?
Where is that? Eddie must have returned.
There is no speed post receipt here.
Nothing.
In speed post, there is no AD, my
So
lord.
track report is not there, nothing is there, and court has to assume.
Is concerned in speed post, there is no registered AD.
That is there.
Only speed post sent by speed post.
How to assume?
Because I was worked there in the cat, so I know that.
No, that's not right. We appreciate that. But question is, when postman,
it will be very difficult whether notice is served
or not. How to? Therefore, we cannot decide against him. If a party says I have not been heard, it's a serious allegation. Therefore, you have to show that he was heard. He was served at least, heard or not.
The counter has never stated any document, never filed any document.
Number one. Number two, even hearing would not have changed the position. That argument is available to you.
And your lordship's judgment in the recent case, in the Konaklata Dubedi case, my lord.
From the Harvard bench.
Konaklata Dubedi case, your lordship recent judgment.
Yeah.
Here only. What we have said?
The second wife is not entitled.
No, but how to decide?
My lord, what I humble submit, one permission, 1 minute, my lord. What I humble submit in the tribunal, nor in the counter affidavit, he has mentioned a date of marriage, but today affidavit, he stated that marriage was solemnized during 1994. But in fact, petitioner married in 88, my lord.
1988.
88.
Where is the material?
My lord, I have moved the court of Jamshedpur for maintenance. Maintenance, my lord.
What is that case about? Maintenance case is called as what here in your state?
My lord, miscase, my lord.
Miscase?
My lord.
Miscellaneous case.
Your lordship, my lord.
No, you are not answering our point at all. You are turning the pages.
My lord.
What case was filed for miscellaneous?
Under 125 service.
Yeah, that is miscellaneous.
For maintenance.
A disputed fact matter is approached to civil court.
No, by the time civil court decides, both will be dead. Perhaps at least I will be dead.
Several disputed fact. Who is the first time? How?
What is that miscellaneous case number?
Miscellaneous case number 147 of 2016.
147 of 2016.
My lord.
Filed by your client. So
my client. The case 54 man.
By the petitioner.
By the person.
Petitioner name is?
Sumitra Devi, my lord.
Before the judge family court.
Before the Jamshedpur, man.
Additional principal judge.
This is under section 125.
My lord.
What happened there?
My lord, was on compromise. Direction was given to pay maintenance 7,000 per month.
Compromise with the husband.
Husband, man.
With since day.
Where is that order?
Order is page 44.
Page 44.
Man. And I have given in the additional affidavit also compromise petition.
It was before the mediation.
It was sent for mediation and
amicably settled.
Amicably settled. Why the order dated?
Dated 20th March 2017.
Right now. Petitioner had filed miscellaneous 147 of 2016 under section 125 of plus 12 CRPC 1973. First time. The matter was amicably settled through mediation, and accordingly, learned additional principal judge of family court.
Yes. Family court,
Jamshedpur.
Jharkhand.
Jharkhand. Entered order 20 March 2017, awarding a sum of 7,000 as monthly maintenance. How many days he paid that money?
My lord, he pays till before Corona. Corona he did not pay.
First time. For the petitioner submit that this order was complied with till the onset of
2019, man.
No,
December.
it has come in.
He has to answer.
My lord. December 2019 never paid.
No, that amount was paid in December 2019. First, after the onset of Corona 2019, pandemic 2019, the payment was stopped. How payment was to you? Whether the husband came and put it into your purse,
my husband
or was it paid by check?
My husband paid me.
Right?
Husband paid me.
Paid how?
Through cash, my lord.
No.
By cash and through some amount he deposited before the
court.
Before the law court.
Any order is there?
No, the order is not there. Thereafter, because of that, I made a complaint. Again, notice was issued to the.
Right.
Notice is annex
of payment. How can we ensure that the 7,000 rupees was there? Continue to pay.
My lord, prior to miscase number 146 of 2006, 147 2016, I also filed case during 1998. During 1998, also filed case, maintenance case.
It is
and he
mentioned that it was being deducted from his salary.
Salary, my lord. And prior to my lord, he paying your lordship kindly see annexure 2, page 30, annexure 2 series through my lord. Postal my lord. Postal receipt is at page 5, annexure 5 is 33 my lord.
He has paid by money order also.
Money order also prior to the compromise, my lord.
How much was paying?
Your lordship can do 1600, 1800 per month, 800, and 2 months 1600. That is in 2002, my lord.
Petitioner counsel draws attention of the court to the money order, postal money order receipt, stroke MO acknowledgement, which reflect payment of rupees 1,600 or such other monies, 800, 6,000. By way of maintenance prior to the compromise. These are exhibits.
Annexure 5 series.
Annexure 5 series. In your affidavit.
My lord. Writ petition.
In the writ petition. In the writ petition. Then when he did not make payment.
My lord, I made a complaint. Annexure 7 notice was issued by the concerned court, Jamshedpur.
Then what happened?
Thereafter, the Accountant General Council appeared before the concerned court, and thereafter he retired and did not pay, my lord.
He draws our attention to Annexure 7, whereby the learned additional principal judge family court with order dated 8/10/2021 made garnishee against AG office for a sum of rupees 7,000 payable from the salary every month of the deceased Mr. Raghunath Mali. When a payment was made accordingly, deduction was made from
they have to know payment made.
Not deducted.
Not deducted. Why?
In the meantime, he was retired. In the meantime, he was retired.
In the year
When the information issued by the office of the accountant general, when the information is issued by the office of the accountant general, in the meantime, petitioner retired.
2018.
But he was trying
That has not been implemented.
No, you were drawing the pension period.
No, he's drawing pension. He's drawing pension.
You did not deduct anything from that pension. What is the amount you are drawing as pension?
It is maintenance, 7,000. Direction was there.
You're asking me a question, simple English question. Please understand. What was the pension you had sanctioned to him?
The pension amount has not mentioned.
Not mentioned.
Not mentioned.
When the pension was sanctioned to him, when did you sanction the pension?
Raghunath has already retired from services.
Pension arises only after
he retired in 2018, October 2018. Must have been recorded the pension.
That has not been mentioned.
Oh. In your letter, you see,
in your permanent pension order, BPO.
Yes.
Whose name you have mentioned as the wife?
PPO name Punniya Male.
Petitioner.
Who the before the cat?
My name.
Punniya Male.
Your name only.
No,
My name.
His client.
That is mentioned in the PPO.
The service register, whose name is mentioned?
My name.
Punniya Male.
My name.
No, in the service register during 90, he was the deceased was appointed on 21/10/86, and marriage was solemnized in 88. And during 89/90, joining Raghunath Mali after the marriage, my lord, in the GPF nomination for retirement gratuity and death certificate, my name was Annexure 1 series.
CRG and other things, everything, your name is?
My lord, you will also kindly say Annexure 1 series.
Show that. Whether the second marriages are very rampant in your state? Second, third marriages?
This is not, your lordship has held, this is not legally permissible.
Oh,
But not apart, but
There are such cases.
anybody has prevented you?
My lord.
No. Anybody has prevented you? Go for second thought.
Page 19 minor Annex 1 series, kindly see.
When a marriage of your client took place?
Marriage in 1998. 9/3/1988.
9/3/88.
My lord.
Where it happened?
The marriage between the petitioner and Raghunath Maruti was solemnized in Muri, PS Silli, in the district of Ranchi, state of Jharkhand.
Jharkhand.
My lord.
What any evidentiary material, any ration card?
I have in the additional affidavit, I have filed election card of the and the certificate of the son of
You
the.
filed it today.
My lord, son of the certificate. Reading, son was reading in the native village of the deceased.
Yes, son also.
Native village of the deceased. My husband. Son was reading, my lord. And he is serving, husband was serving at Bhubaneswar. According to him, he subsequently married, according to her, he subsequently married in 94. He admitted it, present affidavit. He has not filed it.
Commission of India. Not money.
When coupled with the criminal case, there is an order for payment, there is a direction to the AG office to make the payment, whether they comply with or not, there is a direction. His son is also dead.
What the son is doing now?
Nothing doing, my lord. He is not doing anything.
They're not doing anything.
Doing anything. Where have you stated?
My lord, I have not
So
stated.
he was prosecuting study.
So I want to cross-examine you.
My lord,
I want to cross-examine you.
lordship.
We enter the witness box then. If you do not see, you are not supposed to say anything out of it. What is there in the pleadings, you have to answer.
My lord.
Otherwise, you
No, there is
say
no pleading.
Otherwise, I have to
Well, there is
cross-examine.
no pleading, my lord. The no pleading.
Son is born when?
My lord.
Son is born on.
Son is born on
Born on my lord 94, my lord.
694. Rohit Kumar.
6. 1994.
Where is your marriage record?
Yes, he has
When
passed
did you-
board of secondary.
He has passed the secondary exam, Board of Secondary Education. That is SLC.
No, board of secondary education.
HSC, my lord.
This is the enrollment card.
CHS.
CHS. Under Council of Higher Education.
And he passed at my lord, the native village of the husband of the present petitioner.
Secondary. PSC, Orissa.
That is Kusumi.
Your name was mentioned in the service register.
In the gratuity, in the nomination form, that is nomination for benefit under the Central Government Employees Group Insurance Scheme, and in the nomination retirement gratuity and GPF nomination form. During 90, my lord.
GPF form.
GPF
Nomination form
1. Then
nomination for retirement gratuity, death gratuity,
DCRG.
my lord. And my lord, nomination for benefit under the Central Government Employees Group Insurance Scheme.
Group P.
GI,
Yes.
my lord.
CHS. Oh.
So this Annexure 1 series.
My lord. That's wrong.
Annexure 1 series. Yeah.
Good.
When marriage of your friend.
My lord, your lordship, kindly give a glance my additional affidavit today I have filed, including marriage photographs, my lord.
Photographs.
My lord.
Yes, different of you, perhaps. The marriage happened when?
94 minor.
Which date? Where?
30th May 94 minor.
Your response number, which OP number? What is
4 minor.
OP 4. Name?
Purnima Mali minor.
Purnima. Where marriage took place?
In my native
Married
place.
on?
There is no mention.
Let him see. Married on?
Married on which day?
31st May 1994.
Where?
The native place.
Where is the material? Native place means which?
Marwan. In Odisha. Where?
Oh, Odisha.
In Odisha. But he's the man from.
Married on 31/5/94. Where it was, marriage took place?
In the native village of my clan.
Which is that place?
I have not collected that.
See how marriage is to be proved. Which place marriage happened? Who had come to marry? Whether this Saptapadi, Vivaha, Marundati, Nakshatra, Darshana, these things have happened or not. Where is the material?
Neither before the tribunal nor in the counter of it disclosed.
Let me answer. Put him question, my lord. On the last occasion, Lord said directed me to file any evidence, my lord. Lord said kindly give a glance page 6 of my additional affidavit, my lord.
Affidavit.
My lord.
What the affidavit says?
Enclosing evidence, my lord.
What is that?
That is the letter dated 4/9/2018, my lord.
Huh?
4/9/2018.
What is that?
Issued by one of the departmental respondents, by which they have cancelled the CGSS card, which was issued in favor of my husband, my lord. That contains the name of my class, husband, and 2 sons, my lord.
2 sons are there for you also.
My lord, I have blessed with 2 sons.
He is blessed with 1 son.
1 son.
Then
Yes.
both appear to be victims of fraud. By the
Basic,
deceased.
my lord. Logically give us space 6. Then, my lord, I want to place para 2 of the counter filed by the department.
Right.
At no point of time, she come forward claiming to the wife of my husband, my lord. And for first time, she came before the authorities in the year 2023, my lord. After
But
death.
there is a lot of evidentiary material
Your lordship, kindly give
to
me
prove the marriage.
I am placing the counter filed by the department, my lord.
No, what department will say? Whether that person married or not, no person
So,
from
my
the
lord,
department will go for participating in the marriage.
That point, whether marriage take place or not, I cannot answer.
No.
It was not within me, not my knowledge.
No, both you are victims only. We understand. Both you have been victimized.
It was only give a glance page 2, para 2 of the counter, my lord. Filed by the department.
Para 2.
My lord.
Page 2, para 2.
Para 2 of the counter, filed by the department.
Department.
My lord.
What the department has said? Read.
I am reading, madam. Sri Raghunath Mali joined in government service on 21/10/1986 in the office of opposite panel 2. The government servant has nominated Purnima Mali, that is opposite panel 4, as his wife, and the same was accepted by competent authority on 22/7/2013. Copy of nomination dated so and so enclosed as Annex A. Third, at the time of availing leave travel concession for block year 12/13, hometown extension Sri Mali has availed LTC from 2014 to 16 to 2014, along with his wife, SM Punya Mali, by office order number so and so dated 19 to 2014, and the same is recorded in the service record book.
But earliest records, GPF, DCRG, group insurance scheme, mention her name.
No, my lord. These are the forms. These are not record of the department, my lord.
No, these forms are filled up by who?
They are saying they are not aware of anything else. I cannot say.
Who can say?
The department is saying.
You are putting the department in no problem, no? You can put them in problem.
Something has to be.
No, they have to be. See the documents.
Yes, my lord.
See. But if another one is.
Court
order is there.
Read article, which is that article which says full faith credit doctrine. Article 160, 262, something like that. In our constitution says the court record should be fully believed. There is such an article.
which rarely is seen by the lawyer. And prima facie, the court also held that there is a husband and wife relationship. Otherwise,
Why there is a direction to, there is a garnish order to the department to pay the maintenance.
Husband admitted, man.
Your client is also a victim. We appreciate that. That is another thing. But there is one judgment of, I think, my judgment on full credit doctrine of full credit. 261, Article 261 of the Constitution says, full credit should be given to the court records. Judgment of that effect. You know that?
it is countersigned by senior accountant officers. Even if they have not mentioned in their counter, then there will be a problem.
But now,
what they have said in the counter, that I'm placing my.
That's
They are saying for first time.
Two officers put their signature, man.
They are saying that for first time Sumitra Malik came before them in the year 2023, man.
That does not make any sense.
Their staff paper is not available with them.
That makes no sense because there are court records where he was directed to pay the maintenance. Number one. When he did not pay, he has paid some maintenance also before the court conciliation. 6,000, 1,600, 800, that's their record, number one. Number two, there was a direction, there was a garnish order made against the AG department. But AG did not obey it because by that time he had already retired.
He was on a party that process.
No, by then the other wife had already claimed.
Already claimed.
Party.
No.
Garnish order is made only against.
I had never put any claim, man.
Garnish order.
My claim arises after death of my husband. I have never claimed opposed any claim over because I was not aware of any claim about here. I claimed my grant of family pension after death of my husband, man. When the department
He is husband to both of you. What to do? We have held during this subsistence of first marriage. We have held that. Apex court has, we have referred to that Apex court judgment, and then we have referred to the mains on Hindu law, and we have written that judgment. But question is, it's not that simple. Something both you have to settle. Otherwise, both you will not get. You have to fight the legal battle for another 1 decade.
I will not see the right.
Instead of that, you sit across the table, come for some settlement. See, there are 2 children to her. There is 1 child to you. It has already passed that with the BSc, Board of Secondary Education. So sit across the table, do something. Otherwise, we do not know. We may tell them to credit the entire money in the registry till your dispute is resolved. Instead of that, you sit, take this judgment, Srishaila Muchundi versus State of Karnataka. But the report, we have considered what credit should be given to the proceedings of the court. That's called the full credit clause in American jurisprudence. We have borrowed it to our constitution. Full credit clause. Because he has fought the litigation earlier. In that, your husband was her husband. Therefore, sit down, tell us as to how we should decide. Instead of battle going on endlessly, we will decide 50-50 pension. That appears to be sensible. Till one of you will go to the court and get the declaration. Otherwise, both you will not get. There are court proceedings between your husband and that lady.
Will not you grant some time? I will take instruction from class. I will say yes or no, man.
Correct.
She may agree or she may disagree with me.
That's true. You just have a word with your client and come back. We'll have this matter on 16.
17, man.
17. I get it. 17 will be Friday, no?
Friday.
Then 15, man.
15 have some personal. 17 will be Tuesday.
Yes?
17 will be Tuesday.
21st, my lord, 21st.
You, huh?
18, my lord, 18 is the bonus.
18. 18. Father,
Records are
83.
records of the
You just see that pursuant to our order, the records were produced and seen. Thereafter, records are given back so that on the next date of hearing, the same shall be made available to the court. You take it back. You just also advise your client that way, not? Otherwise, both will not get.
My lordship is right, man.
they will get to civil court.
During lifetime, neither she nor I will got mine.
Therefore, sit across the table and do some work.
Sir,
This land court last directed that
Make use of mic. Take mic. Grab that. Yes.
as per this court direction, petitioner has been advised to pay pay the amount which has been 36 lakhs in 12 installments by 6th March 26. Petitioner has been paid 20 lakhs and we have filed an IA for 2 months time.
2 more months.
2 more months.
How much you have paid now?
You have paid 20 lakhs?
Yes.
Out of 36 lakhs? LIC housing, no?
Yes.
I'll go to the order now. Is it entry model?
Yes.
Final order or entry model?
No coercive action. No coercive action to be taken against them.
No coercive action to be taken. Which is that order? Where is that order?
28-1.
28-1.
2025.
Who appears for, who is your friend?
For the LIC.
Madam is saying, your sister is saying some 22 lakhs she has already paid.
Yeah, in the last occasion, Lordships directed to pay 12 installments.
Yes, on
17th of February, madams. Out of which they have only paid, which is amounts to rupees 42 lakhs somewhat. They have paid, out of which they have paid only 20 lakh rupees. And still they haven't paid 22 lakhs is still pending, my lords.
They are saying two more months are given, they will pay. After all, you want money.
They have been taking this.
But interest, you will get interest on that also. For the delayed period, you will be getting it. Now they have shown the bona fide.
2 months is a very long time. 2 months is really long.
2 months will give. Because they are making the payment. They are not running away. There may be some difficulty for housing scheme. Yes. But yes, sir. 2 months they want now. And bona fide borrower. All right. By your a coordinate bench of this court, by the order dated 28/1/2025 had said as under. Next paragraph. Subsequently, this bench also passed an order on 17/2/2026, which has the following text. Learned counsel for the petitioner submits that already a sum of rupees 20 lakh has been remitted to the loan account, and that because of financial difficulty, a period of 2 months be granted for making good the installments that have fallen due. First one. She also highlights the difficulty which her client is facing. First one. Learned counsel appearing for the OP LIC opposes the application, contending that relaxation cannot be granted merely for askance, and that petitioner has to show bona fide by complying with the interim orders made earlier. First one. Next paragraph. Having heard learned counsel for the parties and having perused the appeal petition papers, we are convinced that petitioner happens to be a bona fide borrower, and that maybe because of pleaded financial difficulty, now he is seeking extension of the period through this application, which is supported by an affidavit. First of all, such a bona fide borrower can be put to prejudice, especially when a huge sum of rupees 20 lakh is already remitted in terms of our orders. First of all, no prejudice should be caused to the other side, since extension of the period will also carry interest. First of all, if application is rejected, petitioner would be put to a manifest injustice and a great hardship. First of all. Next paragraph. In the above circumstances, application having been favored, an extension through 2 more months is accorded, subject to the condition that if benefit of this extension is not availed, the petition runs risk of dismissal. First, ordered accordingly. Yes.
Item 15.
For this matter of the court.
My lord, interim order to continue.
With the above observations, interim order would continue. Call after 8 weeks. Next.
Item 15.
Right. Sister, what's your name? Right. Yes. Next.
Rosmi Sinha.
Yes.
Item 9. 15, I am appearing for the opposite part number 2 bank.
Serial number?
15, man.
1 spy.
Petitioner. I am appearing for opposite party number 3, your lordship. I pray for an adjournment, your lordship. My senior having some personal difficulty.
Whether you are for OP?
Opposite party number 3.
Any interim order was passed?
Yes, ma'am.
Whether that order is complied with?
The interim order to, that was staying the surface application filed by the my lord, the borrower, with number 3. Now, what has happened in this case, my lord? Section 17 application was filed before the DRT by the my lord borrower, and by that time the sales certificate was issued, but still, my lord, the DRT went on and passed an interim order saying that it's deposit the entire paid amount. That has been deposited and interim order is continuing. Now, being agreed, my lord, the auction purchaser has filed this application before this honorable court. There is an interim order not to proceed with the essay, my lord, because there has been the contentions where that the auction purchaser has not been made a party even till today, my lord.
You impede auction purchaser.
When she is the
you are, who are you?
I am the option purchaser.
You are party to this. Have you made an application?
She is the petitioner.
I am the.
You are the petitioner.
I am the petitioner.
Before DRT, she is not the party.
Even today, my lord, I was checking the records, my lord. I don't think she has been made party even after passing the interim order also. But she is supposed to be made party, my lord.
What was our order?
Not to proceed with the essay.
No, that was also till next day.
Yes, ma'am, till next day.
It is not there in.
As on today, my lord, on the last occasion, that has not been extended. Yes.
On 11/7/2025, it has not been extended.
11/7, it has not been extended, and rejoinder was directed to be filed. I don't know whether the rejoinder has been filed, but we support the case of the petitioner.
You are supporting case of because you are the
because, my lord, I am suffering the interim order passed by the DRT, my lord.
Anyway, they want a short accommodation. Next week will come this matter. Well, this matter next week at the request of Learned Counsel for the petitioner. OP number 3. OP 3.
Excepting barring 18th, my lord.
Which date?
Any date, my lord, your lordship.
You choose one date. That date would be given.
If she does have the.
This is March.
Well, March. Sorry. March.
Whichever date he says.
24.
24 all right.
Next, item 16.
Your Lordship, may I make a humble prayer? Your Lordship, there was this interim order for the stay of the.
Yes, till next date of hearing. The interim order earlier made would continue.
Much obliged, Your Lordship.
Yes.
Lordship, this instant application was filed earlier seeking directions against the auction notice that was published by the LIC Housing Corporation Lords.
My lord, that auction notice dated 4/2/2000. 26.
Did it materialize?
Has been, no. My lord, it has been cancelled. The loan account has been closed and he has paid the entire dues on OTS basis.
Millard's has been rendered infectious. The husband has come up after.
Anyway, it has become infectious now.
Yes, Milord.
The entire money is paid.
Yes, Milord. The entire money has been paid.
Give some record so that we can record that.
Status closed.
Loan account is closed now.
Closed. That is details.
This is closed on which date?
On 26th February. 26th February it was closed and 6,36,500 was deposited for closure of the said loan account.
Petition prayer reads as under. Next paragraph. Learned counsel appearing for the OP number? OPs.
But not the private opposite party members. The husband was also included as a party.
Anyway, lending OPs.
Yes,
lender OPs.
Which one?
Filed a copy of statement of account.
125.
OP 125 has filed a memo dated 9/3/2026 along with a statement of account to the effect that the loan amount having been completely remitted by the borrower or wife of the borrower?
By the
applicant.
The son of the borrower.
Who is the petitioner?
No, the petitioner is the estranged wife.
By son of the borrower. Come on. Petition has become infectious. First off, we agree with this submission. First off, in the above circumstances, petition is disposed of as having become infectious. Yes. Statement of relevant part of statement of account dates as what am I?
Weekly list item 1.
Yes, sir.
I am the appellant here. The appellant was appointed as Anganwadi worker in the termination vacancy of respondent number 5. Respondent 5 challenged the order of termination before the Hon'Ble Court. And while the application was pending, the advertisement was issued by the competent authority. I was selected in due process of selection, but I was not made a party, nor the matter was very near to the heart. I was not given an opportunity. Now I have come to know, my lords, what my learned friends have told me, that there is a process is going on by the government, so that both can be accommodated. That is what I am told.
The government has to say that, no? If both can be accommodated, why can't you accommodate?
They have to take interest. There is no such.
Call next week.
One captain. AOE captain.
No way. Only is no such. Leave of your lordship. My termination has been set aside since 2019. I was terminated.
2019.
In that vacancy, I was appointed.
To that vacancy,
during pendency of the writ petition, the state government did appoint a person without intimating this court or even to the petitioner. And the
appellant is the
person. The notification was also under challenge. That is merits of the case. But now the document has been there. So I have got the information
that the collector and district magistrate, who is the appellate authority or the competent under the Anganwadi worker scheme, has recommended a proposal to the state government in its Child and Women Development Department to bifurcate the same Anganwadi because of its strength has increased manifolds to make a...
So both can be accommodated.
Yes, that is...
But why you were terminating?
Termination is 2019.
On what ground?
Well,
on what ground?
Leave. I had taken 3 days leave in my 19 years of service without affording an opportunity. I was terminated. On the date, I gave my so-cause notice.
She was frequently absent, my lord. Public are objected for that. We judges remain more than that, absent more than that. No, my lord, not for 3 days.
3 days.
No, 3 days, more than that.
No, that is 3 days. 3 occasions.
Or if you say that he was habitually an absent.
Habitual, right. Correct. That is the correct. Totally 3 days in 19 years.
Well, those 3 days applications, they spanned it to 31 days. Even if I admit that 31 days, in 20 years, 31 days, they say I was irregular. And who said so? The villagers. And on
the beneficiary, my lord. They are the beneficiary. The scheme works are not done because of absence. Did you give the opportunity to explain?
No.
Why she was absent? That has been provided. Record says, my lord,
that has been taken care of by Honorable Single.
And after disgraduated, my lord, he
allowed it and set aside the termination.
Yes.
Lordship.
But if it is set aside, what is your right?
My lords, I was appointed. I was continuing. Till today, I am continuing, my lord.
That makes no sense. You are buyer pendant and it is 152 say list pendants. This is case of list pendants.
My lords, am I not to be given a chance to press my case whether by continuance? That has not been given, my lord. That is why I am.
No question of paying to you. You are list pendant. You are appointee list pendants.
If they are going to consider, let them consider, my lord.
Let them consider. That observation we will make.
Yes.
We will dispose of now. You have no right. You have no right to lay challenge to this order. Because during the pendency of his litigation, you came to the appointee.
And it was brought on record by the counter by the state.
Well, that makes no sense.
Knowing that they did not make me a party, nor I was given an opportunity.
You will not be made a party. A list pendant buyer will not be made a party. He will be bound by the decree. Under Section 52 of Transfer of Property Act, a person who buys the property in dispute is bound by the decree whether he is a party, a nominee or not. 1951, Calcutta, Justice S.N. Bose judgment. We'll make one observation. Now we are told that it is being bifurcated and both can be accommodated.
Suggestion is there.
There is a recommendation.
And you also may make an observation. In the event any action to be taken against the appellant, she has the right to approach. Otherwise, they will see that for all time to this has come to an end.
We'll make that observation. Whatever you want to do. If they are aggrieved, they will come again here.
Yes, ma'am.
All right.
Advertisement apply fresh advertisement.
This intra-court appeal by a non-party seeks to call in question which order?
My lord, that is annexure.
That is annexure 4, your lordship's brief.
Just a minute.
No.
Let me plead it.
Okay.
Annexure 4 at page
125, whereby your respondent number
5 man.
Fifth respondent's WPC number 33632 of 2021 having been favored, her termination is set at naught with a direction for reinstatement. With a direction for reinstatement. Appeal is, have you filed application for leave?
No, ma'am.
How?
Yes, ma'am.
An application seeking leave of the court to prosecute the appeal is also moved. First one. Next paragraph. Kindly be seated, please. Learned counsel, learned senior advocate appearing for the appellant, vehemently argues that the learned single judge has grossly erred in granting relief to the fifth respondent by way of reinstatement to the post to which the appellant has been nominated, and that too with no opportunity of hearing to her. First of, therefore, counsel submits, impugned order is liable to be set at naught on the ground of violation of principles of natural justice, since her breadwinning itself is put to stake. First, learned counsel appearing for the contesting OP5, respond 5, opposes the appeal on the ground of maintainability by invoking the doctrine of lispendence. By invoking a doctrine akin to lispendence, akin to lispendence. He submits that the appointment of the appellant to the posting question happened when the removal of his claim was put in challenge before this court, and therefore any appointment in such a situation would be subject to outcome of the list. First one, we agree with this. First one, a person appointed when appointed to a post when the earlier incumbent had put in challenge his stroke her removal has no right of lien to the post in an absolute way. First one, it is more like an interim arrangement subject to outcome of the event which caused vacancy in the post in question. First one. Next paragraph. Now we are told at the bar that the subject Anganwadi center is being bifurcated, and eventually 2 posts are available. Eventually a recommendation is sent for fructifying the bifurcation and making the appointment to the eventual vacancies, and that the said proposal is pending before the government. First one, suffice it to say that the government should take the call at the earliest in its discretion. First one, in the event the decision of the government goes adverse, aggrieved person may challenge it, and in that connection, all grounds are kept out. First one. Next one. With the above observations, writ appeal is disposed. But when are you implementing order of the single? That
is what I like.
One more case he has to file. He has to file.
That will be implemented.
It is not created.
Because state has not filed it appeal.
No, therefore you have to abide by the order.
Yes, my lord. I think
the order of the learned single judge shall be implemented within an outer limit of 8 weeks. and a compliance report shall be filed with the Registrar General of this court. Yes. Within a period of 8 weeks. Here it should be. Yes.
Grateful. Item 2.
Item 2, my lord, I have a no record, my lord. What's the time next to 2?
2 weeks at the request now. Next.
Item 3.
Yes.
My lord, appellant Ms. Mahapatra is appearing to code note 12. Two case possible.
Possible.
Item 4.
For nobody?
Yes, I am there.
My lord, I am there.
That's, yes.
My friend is fine. Government is
1829.
What is this matter of Mr. G?
My lord, it's a
for
regularization of an employee who was appointed against a non-sanctioned post.
Non-sanctioned post. How long he has worked?
She has worked more than 10 years.
More than 10 years?
3%.
Huh?
3%.
3%.
In all, in Mumbai.
More than 10 years?
Yes.
Those were
2010. By today, my lord, 15.
Lordship, I am placing the conclusion part, page 63 of the judgment.
Yes.
In view of the aforesaid analysis, taking into consideration the long period of continuous and unblemished service of more than a decade rendered by the petitioners, and further taking into consideration the nature of work performed by the petitioners at the establishment, as well as the recommendation made in favor of the petitioners for regularization of their services, and keeping in view the judgments discussed herein above, this court deems, while allowing the present petition, directs the state parties to regularize the service of the petitioners against the available vacant post from the date of such posts were created by the government of Odisha, with all consequential service and financial benefits as would be due and admissible within a period of 8 weeks from the date of communication of a certified copy of the judgment. Accordingly, the petitioners are directed to reinstate this in service forthwith. In the event they are disengaged from service and disburse all pending remuneration and consequential service and financial benefits as is due and admissible to the petitioner as expeditiously as possible. And accordingly, this writ petition was disposed of. Now, I had filed this writ appeal because on 2 grounds, my lord. One is the contractual rule. No, sorry. At the time of appointment, there was no sanctioned post. One. Number 2 is
what work they are doing?
They were attendants in Odisha Bhavan, New Delhi.
Mumbai.
The
employee of the state. That is governed under the Department of the Home Department.
They worked for 10 years.
Worked for 10 years. But the judgment says, my lord.
No, what you say? Judgment
couldn't claim.
Do you dispute that?
My lord, their lordship have also cited so many judgments. Jago, etc., so many judgments. Jago, Shripad, all the judgments.
Yeah.
7 except, my lord. Their lordship have referred the judgment of State of Haryana and others versus Piara Singh, Jaydev Srichandan, and
Kumar, 2024 1 SCR.
Yes, my lord. Jago,
judgment.
Nihal Singh, Amarkant Ray, Narendra Kumar Tiwari, Shripad, and Jago. My lord, but recently, no, it is another is there. Bholanath is there. My lord, in Bholanath case, my lord, their Lordship have said clearly. Lordship, I'm placing that. The final conclusion. In the light of our discussion in the foregoing paragraphs, we summarize our conclusions as follows. My lord, I'm coming to paragraph number 5. In view of the foregoing discussions, we direct. This is the directive portion, my lord. The respondent state to forthwith regularize the service of the appellants against the sanctioned posts to which they were initially appointed.
It was a case of sanctioned posts.
My lord, it was a case of sanctioned posts because they were appointed against a sanctioned post, but they were not regularized. But here is a case, my lord. It is a non-sanction. It is not a sanctioned post.
But why did you continue them for 15 years?
10 years, whatever.
No, may interrupt. There is a sanction in our favor.
Where is that?
Yes, that document is there. The recommendation is there. Shall I read the recommendation itself?
Where is that?
Yes, that is in the writ petition itself.
Whether learned single judge has mentioned that?
Yes, everything has been taken.
Where has he mentioned? The posts are sanctioned, not sanctioned. Where is that finding?
Paragraph 3. Paragraph 3 of the judgment.
Go to 3. 3 may be contentions, no?
My lord, initially the petitioners were appointed on a contractual basis for 6 months, and their appointments has been regularly extended from time to time. It is evident from the document on an Annexure 5 series.
No, but the post-sanctioned post, where is that point?
It was not a sanctioned post. How he is saying, I do not know.
No, Annexure 7, the time. Okay, something. But kindly see Annexure 7 to the writ petition. To the writ petition. These posts have been, 3 posts has been created.
Where is that?
My lord, page 54 of that writ petition, Annexure 7.
If we have recently created 3 posts.
Finance Department recently 3 permanent posts against which these candidates will be recommended to be observed.
What is this? Who has sent this letter to whom?
This is the secretary from the Home Department. This is a communication to us by the RTI. These are the documents.
Annexure 7.
My lord.
Have you disputed in your objections? Did you dispute the authenticity of 54?
No. And therefore, a recommendation was by the Resident Commission, Annexure 8.
What?
Yes, kindly see page 58.
Recommendation also?
Yes, page 58. The employer there at Mumbai. He has written to the department. Page 58, Annexure 8, my lord. The regular appointment of existing contractual employee, Odisha Bhavan, New Mumbai.
Yes, that ground is not available to you. Posts are created. The recommendation is also made for their regularization.
My lord.
But what remains in your hands? Nothing. You can say you have vehemently argued. Dismissed. Yeah.
No, at the time of recruitment, there was no creation of posts.
Subsequently, have created. That shows that there is a perennial requirement of service.
For the first time in 2000,
that goes without
this.
That goes without
This Odisha Bhavan was newly created.
Vanamala judgment. If there is perennial requirement, the argument that posts are not sanctioned will fall to the ground.
Are you going to close the just now?
Now they have
That's not your case.
Rather,
They have recommended also. That's also. Yes.
Okay.
Dismissed.
Item 5.
The order of the single judge shall be implemented within an outer limit of implemented, and compliance report would be filed with the Registrar General of this court within an outer limit of 3 months. 3 months.
Item 3, the appellant to.
That's 3 months.
3 months. 3 months.
In item 3, I appear for the respondents.
3. Yes, Mr. Sarangi.
Yes, well, appellants I not sought a passover. I have some difficulty for the day. If you lordship would accommodate me some other day.
Next week, you inform the other side. Your friend will inform the other side because he got the Passover. Now he is not here. So let him come because we have passed it over.
I will inform.
You will inform? Yes, call next week at the request of senior locating Sarangi appearing for OP number. You are for the appellant.
I am for the respondent. Contesting opposite.
Contesting respondent. Next.
Item 5. Item 5, my lord, I raising more time to prepare, my lord.
2 weeks. Next request.
Item 5, notice only delay has been condoned. And the direction of the single judge only for two national benefit, no financial benefit to the present respondent number 1.
What is that order? No, he wants some preparation. He wants to let it come after 2 weeks.
I'm having list of dates because some dates are relevant.
No, we will take up this matter after 2 weeks so that he wants to read and come.
Next week.
I'll call next week at the request.
Item 6.
Item 6. So, sir, let it come in the next week.
Yeah.
To see.
My lord, in some item I am there, my lord.
Yes.
That first item different than my matter, my lord. It may be untagged, my lord.
Untag writ appeal 1564 of 2024.
Yes, ma'am.
Yes.
Obviously.
Call
Take
after
me
2
till-
weeks at the request.
Next week.
Next week.
Yes.
Next week at the request.
Obviously.
Yeah.
Item 7.
Yes, sir.
The disputed land was a road recorded in the Sabik ROR, published in the year 1930. During consolidation operation, it was wrongly recorded in the name of Hello.
Who are you?
I am the village who are using the said plot as road. Me along with other villagers are using the road as the plot as road.
No, you were using or the villager?
No, I am using. But other persons, all the other villagers are also using the same plot as road.
Road to approach what?
To the village road, government road, man.
Barring this, there is another road.
No, there is no alternative road.
So whole city, the village life will come to an end.
Exactly, my lord. There is no alternative road to the approaching.
Yes, Mr. G, is it true?
I do not know. Well, let notice be issued.
My lord, it is a recorded as road in Sabik ROR, my lord. In the published in the 1930, my lord. Subsequently wrongly published as a Stitiban status in favor of the opposite party in the consolidation operation.
You take notice.
Private parties are also there.
Must take notice. Learn it ETA Mr. G on request WhatsApp notice for 1. You must take notice to the rest. Returnable within 4 weeks. Yes.
Item 8.
May I please your lordship, my lord, here the respondent number 1 and 2 didn't receive any counter till now.
You have not received counter?
Yes, my lord.
You are appearing on behalf of respondent number 3 and 4. Opposite respondent number 1 and 4, the CMD of the bank and the general manager of the bank is there. Notice has already sufficient, my lord.
The notice has gone to them.
My lord, I have not appeared on behalf of them because the Boklatama has to come from Mumbai.
So you have
We will request you to appear for them so that you can tell your client what has requested.
In the petition matter to the people, the Lawrence Single Judge, I have appeared only 3 and 4 and I argued the matter.
How does it sort on them?
Yes, my lord.
Yes, my lord.
If your lordship grant me 2 weeks time, I will ensure them to file.
Why not necessary? We will say it's served and unrepresented.
They are the officers.
They have chosen to remain unrepresented, in their wisdom. Maybe they are very sure that we will not pass any order adverse to their interest. It may be.
2 weeks time will be granted and the other I can
call up for 2 weeks. Get the request out. Yes.
Item 9.
Witness Lordships.
Yes.
Lordships, I number 92 of 25 may kindly be ignored. It has been wrongly filed. There is no delay in filing the writ appeal.
Application for the applicant submits. Application number 92 of 2025 has been filed seeking condonation of delay when there is actually no delay. First off, she tells us that the application be disposed of accordingly. First off. Ordered accordingly, the IA is scored down.
Your Lordships, the appellants have challenged the order dated 4/12/24 of the Honorable Single Judge of this High Court, dismissing the writ petition on the ground that it has been filed after a period of 29 years.
29 years.
Yes, Your Lordships.
Very short delay. Is it true that you have filed the petition after
Yes, Your
a delay of
Lordships.
29 years?
Yes, Your Lordships.
What is the what was the matter? This
Your Lordships, the appellants were appointed as Shiksha Karmis in the year 1991. And the Department of School and Mass Education issued a resolution dated 2/11/94 to regularize the untrained SC and ST Shiksha Karmis as primary school teachers with effect from 1/12/1994. But the present appellants were regularized
1/4/95.
Yes, Your Lordship, 1/4/1995. And they came to know about the situation in the year 2018. Your Lordships may kindly see Annexure 4. Similarly situated persons were appointed as primary school teachers with effect from 1/12/1994.
What the difference will be how much?
Your Lordship?
5 months.
4 months.
4 months.
Yes, Your Lordships.
What benefit you will derive by adding 4 months to this?
Your Lordships, it has a differential area and other consequential service benefits.
Is it true that the others have been given benefit from 1/12/1994? Where is the question of delay?
Delay is he has approached this honorable court in delay. In 24 he has approached.
The question of delay. That does not make a delay. The expert has said, no?
Is it go for recovery or what? You go for recovery.
No.
Without listen, you can. No, Mr. G. There are judgments. Where is our Karnataka High Court judgment? Division bench judgment is there. In matters like this, there is no concept of delay.
No, my lord. Here is a case of
What are they? What are they?
Shiksha, primary school teacher.
Primary school teacher.
Primary school teacher Shiksha Karmi is a project, my lord. It's a
no, but to
scheme.
Have given.
Yes. If others were benefited, then
that has to be extended. Where is the question of delay?
But
the single judge says there is a delay. First, delay concept is not applicable to writ petitions. It may be at the most delay and latches. Delay would arise under the Limitation Act.
Here, and single judge has said that the present writ petition has been filed after more than 29 years.
That itself, the very idea is wrong.
To antedate the date of regularization, this court is not inclined to entertain such a writ application.
We don't, with due respect, we don't agree with him. See, you take notice and you make a statement.
My lord.
Emergency notice. Requested for
opposite parties.
All respondents. Call up, since matter lies in another call up to 4 weeks. Yes.
Item 10.
Much obliged.
Petitioner in this case seeks to ourselves Annexure 10, and by that order, this Honorable Single Judge dismissed the writ petition on the ground that he has filed a writ petition prior to it, and in that petition, the order was passed. And that order, or pursuant to that order, his case was dismissed, rejected by the opposite party, number 4, state government. But that is not true, man. That is not true.
You have not filed writ petition.
Pursuant to that writ petition, only court directed the state government to consider my case, and that representation was dismissed on the ground. Your Lordship kindly turned to Annexure 7.
That was rejected.
That was not rejected, man. That was not rejected. Your Lordship kindly turned to Annexure 7.
15/4/2024.
Mine. Page 35.
Yes, Vedanta was instigated to 12/1/89, subject to outcome of FAO. Pending, what happened to FAO?
That was dismissed. That was filed by the government. That was dismissed.
Therefore, that would add merit to your case, because the FAO was filed by the government.
That was dismissed, my lord. That
Yes.
was against me, my lord.
Yes, that is what.
That is against you. It is in your favor.
It is in my favor. But the FO is against.
Take notice. Issue emergent notice. DGH is requested to accept notice for 1 and 2.
1 and 2.
1 and 2. Emergent notice for 3 and 4. Yes.
Item 11.
May I believe Lord, by the impugned judgment, yes, the Honorable Single Judge, by the Annexure 9, my Lord, the judgment starts from page 35. My repetition has been held to be not maintainable, holding that the judgments cited by me are per inquiry and appeal will lie. I challenge that order, my Lord. My Lord, this is
that judgment said appeal will not lie.
My Lord, I have cited 2 earlier judgments that appeal will not lie. But some indirect decision thereafter that appeal will lie. Holding that my case, though it is of 1970, that appeal will not lie, that petition is maintainable. But English judge hold that my judgments are per inquiry. May Lord may kindly see the last portion of the judgment. Paragraph 6.6, page 61, my Lord.
That Digambar Pradhan.
My Lord. My Lord, paragraph 6.6, may yes, my Lord.
Appeal to be filed within 30 days.
My Lord, yes. But it is an interim order. My submission against the interim order, no appeal is maintainable.
Which act?
Odisha Gram Panchayat Act, my Lord.
In the section, let us see.
Section 38, my Lord.
Yes.
If the civil judge junior division, after making such inquiry, as he deems necessary, finds in respect of any person whose election is called in question by a petition that his election was valid, he shall dismiss the petition as against such person and may award cost at his discretion. Then 2, if the civil judge junior division finds that the election of any person was invalid, he shall either A, declare a casual vacancy to have been created, B, declare another candidate to have been duly elected, whichever course appears in the circumstances of the case to be more appropriate, and in either case may award cost at his discretion. 3, all orders of the civil judge junior division shall, subject to the provisions subsection 4, be final and conclusive. Provided that the civil judge junior division may, on application within 1 month from the date of any of the orders made under this section by any person aggrieved, review such order or
let's review
such order on any ground and may, pending decision review, direct stay of operation of such order, provided for that no application for review under the preceding provision.
That's not your case.
Then 4, my Lord. Any person aggrieved by an order of the civil junior division may within 30 days from the date of the order prefer an appeal in such manner as may be prescribed before the district judge, having jurisdiction wholesale after giving the parties an opportunity of being heard, confirm, reverse, alter or modify the order of the civil judge junior division, and pending disposal of such appeal may direct stay of operation of such order. So my submission is, my Lord,
the word order is final order.
My Lord, yes.
Your contention.
No, I am challenging an interim order.
No.
Yes, my Lord. Under this provision, it is final order. Sorry, my Lord. It is final order.
How various judges of this court have held?
My Lord, I am giving the decisions, my Lord. I have got the copies, my Lord. You may kindly see first. Year 1970, 46. It is a division bench decision, my Lord. Your Lordship may kindly turn to paragraph 4, my Lord.
So the DB.
My Lord.
It holds appeal is not maintainable.
My Lord. My Lord. On a perusal of the various subsection, it is clear.
Which paragraph you are reading?
4, my Lord. Paragraph 4. Page 47 of that flag A, my Lord. Year 1970, Orissa, page 46. Flag A.
26.
My lord. Paragraph 4.
Paragraph 4.
Yes, my lord. Up to paragraph 4, it is quoted, my lord. So, paragraph 2, my lord, section 38 is quoted. Then after quotation, subparagraph 4, then on perusal of various subsections, it is clear that an appeal lies only against final order passed under subsection 1.
Against interlocutory order.
My lord.
This is BB. The same section is interpreted.
My lord, yes. That is the interpretation. And your lord.
1 second.
My lord.
Why are you running so fast?
My lord.
Why are you running so fast? We are considering the law.
Sorry, my lord. Sorry.
Be slow.
My lord, sorry.
What learned single judge says about this judgment?
That it is per incurium.
This judgment?
Yes. But it is incorrect, my lord. On that basis of the finding of the honorable single judge, my appeal would have been held, would have been held to be maintainable, my lord. Because my judgment is fast. The honorable single judge has relied upon, you also made flag C.
Subsequently, which one has come? In 2007?
My lord?
Subsequently, 2007 judgment has come.
No, my lord.
Holding it not maintainable.
My lord, yes. That is not direct discernible. That is not direct discernible. That is not direct decision. There is no discussion whether against the interim order appeal is maintainable or nothing is there. But a lot of flag C. That 1972 1 CWR 74.
Flag C.
C, flag C, my lord.
That is anterior to this judgment.
After, my lord. After. Yes, my judgment is 1960. Flag A. But whereas flag C is 1972.
No, flag A is 1970.
My lord?
Flag A is 1970.
Yes, 1970.
Where is saying 60?
1970. That judgment is dated 17/7/1969. Whereas, slowly.
This is a single judge.
No, my lord, division man.
No, second one, B.
B, yes. Relying upon that, it is a single that appeal is not maintainable, rate will lie.
So that this single judge refers to 1970?
Yes, 69, my lord.
69?
Yes.
Refers to that?
Yes, here 1970 Orissa.
70.
70.
Yes, yes. 70.
It is referred to by learned single judge in 2007. Understand our English.
My lord.
Learned single judge in 2007 judgment. Does he refer to 1970 judge? Yes, it has been referred. On that, on what the learned single judge said on that?
In B?
In B, my lord, that was a case of recounting. Your lordship may kindly turn to...
Interlocutory order can be challenged in that.
Yes, my lord. My lord, just like applying section 105 of the CPC, my lord, in order, if not challenged, that can be challenged in appeal.
Where provisions of CPC are made applicable to this.
My lord, yes.
Which is which section?
Sorry, my lord, I have not maintainable value because it is being done by the civil judge junior division.
So we don't know all that. We are asking a question, you have to answer.
That is why.
It's a question of law. Kind of argument, I do not understand. Is there any provision which borrows provisions of the CPC?
My lord, provision is there, but I am not finding it now. Just now, my lord. Sorry, my lord. Provision is there, it is applicable, my lord.
How that provision is tested? Because
Section 35, your lordship.
35.
My lord.
Procedure before the civil case. You are right. Tried with the civil judge as nearly as may be in accordance with the procedures of case in the CBC. No, as nearly as may be. It's not that. This is considered by Supreme Court, under Supreme Court in Jyoti Basu versus Devi Prasad Ghoshal. Right now, to come without preparation, sufficient preparation I am not seeing in this court. 1982 SC, AR 1982 SC 900 order. Considering similar provision, they said CPC is not applicable.
Madam.
Therefore, your CPC is not applicable, but that question is not raised. But one aspect is, how can a single judge say that region bench judgment is per inquirium?
By taking into consideration this flag C, my lord. They're holding that this flag C decision.
Flag C, it was not an interlocutory order at all.
No, my lord.
Final order.
My lord.
Recounting.
My lord. Holding, my lord, holding that this judgment is earlier to 1970. That is the interpretation.
That is not correct.
My lord.
When that judgment is dated?
Lord of year 1970 is 17/7/1969.
17/7/69.
17/7/1969. Whereas this Digambar decision is flag C, my lord, 7/12/1971.
Take notice.
My lords, maintainability, I question the maintainability,
No,
my lords. My lords,
how can I say, learned single judge say? So easily, one can say, common law jurisprudence says, it is open to any court before whom a judgment is cited to decide whether it is a per inquirium decision, ratio, whether it is a really essential value is got, per inquirium, passing observation.
My lords,
all these are available, but not this way.
my lords, kindly see page 61, findings. And my lords, against this writ petition was exercised by
227,
my lords. Writ appeal is not maintainable.
Full bench has said against 227.
My lord, my 227 where CPC is maintainable, applicable. But my submission is here, my lord. This is a tribunal.
Therefore, 227.
My lord, my submission is I will cite decision on that respect, my lord.
That covered by judgment, no full bench judgment.
No, that is not applicable. I am conscious, my lord, of that decision, my lord. Here, 2008, Orissa, page 46 or somewhat, my lord. But there, it is not said about the special statute.
No.
My lord, yes. I will satisfy on that, my lord.
Supreme Court.
I will satisfy on that, my lord.
What satisfy? We are telling you now, we can't give you time, like, if you want to satisfy, you have to bring entire armory with
my lord.
Not on an installment basis. We are not here to decide matters on installment basis. When you are coming to the war, it's a war of wits. You have to come with full armor.
My lord, I have decision, my lord, of the apex court that writ appeal is maintainable in such cases. So at least tomorrow, my lord, I will satisfy your lordship.
Tomorrow. Whenever we request, whenever you are, this is a war of wits. You can't ask your enemies to wait, give an opportunity of hearing to you. It's a war of wits only. So you have to come with full preparation.
I was not.
Anyway, it's all right. So you bring that judgment. Let us see. Yes.
Item 12.
Yes, item 12 is a matter which it involves a few questions of law. First would be whether a jurisdiction can be invoked. It is a question of an award which can as well be challenged under 34. Of course, this award arises under the MSME Act, Your Lordships.
But 34 is made applicable to that now.
Your Lordships, there is a case law of the Supreme Court that if I satisfy some of the grounds, like if the entire of arbitration law and MSME Act itself has not been followed, then Supreme Court said that it is an award which is void and therefore you can invoke writ jurisdiction. Jharkhand Urja, I will cite that, Your Lordship. So that's the first issue, Your Lordships. Second issue is, Your Lordship, this was a works contract.
Same issue we have already treated. We have rejected this contention in our latest judgment. Just look into them. Which is that judgment that the lawyer had heard before? Identical issue we have already finished you. Just look into this and then come.
Lordships. Very
same contention.
1 week, 1 week. But we had more than that. The other one is that it's a works contract.
That also we have.
Yes, sir.
Just look into.
Then and not following of the conciliation provisions, not following of the arbitration provisions also.
Right.
So I do not know whether they cited Jharkhand Urja.
I think they have.
Okay, but this
They have.
squarely covers. So the Supreme Court judgment. But we look into that, Your Lordship.
We assume that that was also cited. You know that? Give that number to Madam Pami. After 2 weeks.
1 week, Your Lordship. They'll execute the award. That's
Do you have the judgment?
no, Your Lordship. We need.
You are the inspecting counsel.
We both don't have it.
Your Lordship, copy may be served on OP number 1.
We'll but if we admit, then
Have you entered KVA?
No, Your Lordship. Union of India.
the Union of India,
You can ask for copy, but not copy. Unless we order, you have no role to play.
Yes.
But you can enter KVA. If you enter KVA, if you are
No, Your
going
Lordship, we have.
entry order, it will hear you, not otherwise.
we'll examine it. Lordship.
Yes, you examine it, come back. Share that number with. You give it to court. Court answer. Give it. Yes.
13.
I'm not 2 weeks. That's a request.
Next to that. Item 14.
Yes.
The application of the petitioner was also to be allowed. For some, perhaps some, there are some typographical error, Your Lordship.
Yeah.
We have filed the interim application for modification of order for the learned, for the Honorable Single Judge. Denied to accept them. May running page 6, paragraph 13, Your Lordship, may I read it, Lordship? 1.3 of the judgment. The law has already settled that a writ petition under Article 226 of the Constitution of India is maintainable for enhancing the statutory or legal right when there is complaint.
Which paragraph? Which page?
Running page 60, Your Lordship.
60.
60.
Paragraph 13.
13.
Last paragraph.
Last paragraph.
The law has already been settled that the writ petition is maintainable on a person's statutory or legal right. There is complaint by the person that there is a breach of constitutionality on the part of the victim to receive representation. The writ petition of the victim in the case of the company with the writ petition is
where the paragraph 14, where the annexure 3 and 4, Honorable Single Judge pleased to pass it, Your Lordship. The annexure 3, Your Lordship, running page 28. The decision of the LBC that you distill level valuation committee. As well as the annexure 4, running page, Your Lordship, 3.5.
Station as property guideline values.
Where the Honorable Single Judge has pleased was the
guideline values.
The annexure 3 running page for the year 2022-2024.
Who are you?
My lord, I am a petitioner.
No, petitioner. Wow, how you are concerned with this?
I am the writ petitioner before the Honorable Single Judge.
No, petitioner, what is he doing?
What is your grievance for the what are you doing?
Challenging the fixation of highest valuation. I am a production document for a registered registration.
You produce it.
What is that document? Sale deed. Sale deed is produced.
Minor.
No, because of
highest valuation,
stamp duty,
beyond the decision of the district valuation committee. Therefore, petition of the Honorable Court. This Honorable Court also allowed the application
But inadvertently, paragraph 19, on page 62, Your Lordship.
62.
62. May I please read it?
Constitute committee, new committee.
Yes.
That's the direction.
Paragraph 3, annexer, while passing the annexer 3 and 4, annexer 3 or the district the fixation of the valuation, benchmark valuation for the year 2022 to 24, and annexer 3, annexer 4, the fixation of a benchmark goes to 24 to 26. While the honorable single judge plead to quash the same and again fixed the valuation for the year 2020 to 24, that is wrong. 22, 24.
22, 24.
24. 22, 24 has already been quashed by the honorable single judge.
No. That is quashed.
That may be 2022 to 2022. Where the 2024 fixation of benchmark already passed. And thereafter 24 to 26 already cut off. The remaining is 22, 22. 2020 for the year 2020 and 2020-22.
So according to you, it should be 24, 26.
2022. 2026 already passed.
Already passed. Your cell deed is dated?
Your cell deed is dated?
Cell deed I produced, Your Lordship, before the...
When did you present it before the sub-register?
2024.
2024. Now 23, 24 is set aside.
Set aside.
So
the valuation may be accepted by the sub-register for the year 2020 and 2020.
It is passed with the direction to redo the things. It is not that completely it is wiped out and therefore you need not pay the stamp duty. If we go logically,
you go that way,
then you will not be liable to pay any stamp duty. You want to have the free registration of the sale deeds.
That is no benchmark. But it is quashed. It is to be
reconstituted and the benchmark has to be re-established.
Re-established, this is the honorable single judge has plead to directed to
that is how it is
enhance the benchmark of valuation of 10% for the year 2022-24.
When is that?
Whereas the 22-24 has already
Paragraph 19. Somebody has it. Paragraph 19. Go to the judgment, improved judgment. Go to para 19.
Para 19, Your Lordship.
Mr. Behra,
my lords, what has
do
happened?
you understand his case?
My lords, in the impugned judgment, the Honorable Single Judge washed the benchmark valuation made for 2020, 24 to 26.
22 to
24 to 26.
Here. 22, 22, 24. Para 19.
My lords, first para, my lords.
No.
My lords,
Next is the operative portion.
my lords, that I'll explain. Please, page 51, your lordship kindly see.
51.
My lords, para 1. This is for the year 2024-26. Para first paragraph. Since this was washed,
That is not question.
my lords, again reconstitute the valuation committee. There is a provision in section 40 that 2022 last valuation, the collector can enhance 10% pending finalization of the...
Even without benchmark also he can do that.
Last year benchmark.
That will be the consideration. He will do that.
My lords, that is what 10% was, that is the para 19. Your lord.
Now what he says is, when you have question, coupled with a direction to reconstitute the committee.
And there was a direction to enhance the collector may exercise power under section.
So how section reads?
Section 40, my lords.
Read that section. You see, our Orissa Stamp Act is there.
My lords. My lords, Rule 40 of Orissa Stamp Rules 1952 provides that the market value guidelines prepared under the chapter shall be issued as soon as they are prepared and shall thereafter be revised biennially from 1st April. But in case of committee fails to revise the valuation, the collector as chairman
fails to revise the, therefore I asked you.
My lord.
It is not a failure to revise.
My lord.
They have revised it. They have revised it. That has been questioned.
That was passed.
It's not a case of failure to revise.
My lord.
It has been interpreted by under the Indian Stamp Act. Various high courts have interpreted that clause. It requires consideration.
My lord.
Failure to fix is one thing.
My lord.
What has been fixed but that has been set aside by the court is another.
My lord.
Will be reverting in few seconds. There is a Madras High Court judgment by Justice Velli Nayagan. You just look into it. You also look into it.
My lord.
Issue notice, Mr. Behura has requested WhatsApp notice for all office. Yeah, all office. Why so many? All are the state, you know. But how? Why is there concern?
Why until
the collector we can understand. Who he exercises the power. You have done from chief minister, deputy chief minister, home minister, all everything. All right. Matter lies in another comfort, therefore call up to the bodies. Yes. Item 15. What interim application? You have already presented the document. Now what can be done? Once you are presented under the Registration Act, 4 months period for presentation without fine. Another 4 months with fine. Now you have already presented. You pend it. That's fine. Yes. Yes.
Item number 3.
Yes. 3.
My lord, I have prayed for Passover.
No.
My senior counsel has. I am not objecting to that, my lord. But my prayer is, my lord, it has not been hard. It is a fresh matter. And interim relief is necessary, my lord. That's why my prayer.
No, but we have already given you.
No. Your lordship has adjourned that. I am not, my lord, objecting to that. But next week, this matter may kindly call in the press category.
Next week.
Only press.
Agreed. No. Yes. We don't understand things at all. Yes.
Age, because of the age.
We do not. Right.
Item 15.
My lords, item 15, the cost has already been...
Which day? Any date you want?
Any date next week?
Yes. You might inform your friend also.
Yes.
Yes. Yes.
My lords, the cost is already paid.
What is paid to you?
Yes.
Will condone the delay then?
Subject.
Delay is condoned.
Condoned
subject.
Already
condoned.
Condoned. Okay. Mr. Behra submits the conditional order of condonation of delay has been complied with by paying the costs. First one. Counsel for the respondent agrees. Therefore, we also agree with this. Yes. Next.
Item 16.
Yes.
Next week.
Next. You want to argue?
Next week.
To put it week of next. Because next week many matters come up, huh? Yes.
May it please your lordship.
Yes.
The petitioner is an association of retired employees of the Orissa State Housing Board, which is a
Housing board employees.
Housing board employees.
Housing board is a statutory body.
And
any Housing Boards Act is there?
Yes, Housing Board Act is there. Relevant rules have been framed in 1970. Now, Rule 5, Sub-Rule 3, which is annexed at Annexure 2 of my writ petition at page 23.
Age limit.
Yes, sir. The service rules. Service rules in regard to the age limit, leave allowances, discipline and conduct and retirement benefits, including pension, applicable from time to time to the government employees shall apply to the officers and employees of the board. We are concerned with this pension. We demanded to pay pension as per this rule, which they denied, saying
what the learned single judge just said?
My lord, at page 14, para 5, that whatever benefits were due, you have got it, and the present claim has been made much after the retirement. That
no, it should be only after the retirement.
Yes, sir.
Or Mr. G, the rule says pension also. Whatever is payable to the employees, that should be paid to these people.
Housing board.
To take notice. Reasoning appears to be defective.
Nice. I have served the copy on Mr. Learned Senior, Mr. Dayan Mapatu appears for the board.
All right. Mr. Notice, Learned AGA, Mr. G is requested to accept notice for one. Mr.
Dayanand Mapatu, Learned Senior Advocate. Yes, on his chamber I have served. On his chamber I have served.
Issue emergent notice. Returnable within 2 weeks. Yes.
Item 17.
Item 17, the applicant is an Anganwadi worker. Her appointment has been challenged by the respondents for producing a physically handicapped certificate.
Certificate?
Yes, ma'am.
Show that.
Is that
did you tell the single judge that the fake certificate is produced?
No. I am for the appellant. Appellant is here, is the Anganwadi worker. The respondent has challenged the appointment of the appellant.
That is set aside now?
Yes, ma'am.
Did you tell the learned single judge that the certificate produced by the respondent here is a fake certificate?
Not the respondent. It is my certificate which the respondent is alleging.
That is alleged.
You have put
yes. It's not fake according to you.
My lords, it was challenged by the respondent. Initially, it was challenged by the respondent in this honorable court. That was remanded before the learned ADM. The learned ADM decided that based on the reports from the CDMO and the medical register, found that it
is a genuine document.
A certificate has been issued in my name, but the number that is there in the certificate is 3486 and the certificate that I have produced is 8846. That there is a typological error. So on that basis, the ADM...
That certificate was questioned by the government side. Who appeared for the board? No, board was not a party.
Board, although government was a party, but...
board which had issued the certificate, medical board.
No,
that was not a party.
No, not a party.
Mr. G, in such circumstances, Apex Court said, generally who has issued the certificate, he should be made a party, or at least it should be sent to him, asking whether you have issued this certificate. Yes. It cannot be decided between two persons, saying that it is fake or not. How a single judge will say that?
The CDMO has not
the author of the certificate.
The person who issued, my lord, I am appearing for cabinet. He was not in service, my lord. He had retired 3 years back, my lord. He issued the certificate.
Maybe, but that
Records are there.
records are there. It should be what Supreme Court has said. In fact, section 45 of the Evidence Act.
Well, then crime branch investigated into it. Crime branch filed the charge sheet. That is a post certificate, and the criminal case is pending against him. And that report in the charge sheet and report, my lord, he has clearly stated that, my lord, the board was not constituted on that day, and certificate issued by the person who was given. He retired 3 years back from that date. The board constituted.
By the time the
board was not
there.
Not there. Yes, my lord.
Then what is there?
My lords, the case is of the year 2010. My lords, ADM passed its order.
There is already a charge sheet filed against.
My lords,
and the charge sheet material says this is not a genuine certificate because there was no board.
That has not been tried yet, my lords.
No, charge sheet is for civil matters.
Yes, ma'am.
Charge sheet is sufficient.
My lords,
For convicting you, trial has to happen.
Yes, my lords.
But whatever material the police have obtained after investigation, on the civil side it can be acted upon.
My lords, at the time the ADM was considering this matter, these materials were never before the ADM. The ADM was considering.
No, the single judge has considered that. That person himself was already retired.
Placing 2 sentences from the judgment, my lord.
There is nothing.
Another important aspect is that the fact that one of the doctors purportedly signing the PS certificate, namely Dr. Gopinath Vishwa, had retired long ago, that is 13/9/2006.
You dispute that he has retired?
Well, that is not my knowledge whether the...
No, have you said that? In the writ appeal, your ground that person has not retired.
No, my lord, that is not in my knowledge, my lords.
Now you have seen the judgment?
Yes, my lord.
After seeing the judgment, you prepare your appeal?
Yes, my lord.
Have you taken up that contention in your appeal? That the person, learned single judge, says he has retired, but he has not retired at that time.
What point on the appeal is that learned single judge has considered materials which was not before the learned ADM. First, second is it was
that it's open 226 to 227. All that is open. Nothing. Dismissed. Single judge.
Management, give me another opportunity.
What problem?
One more opportunity, my lords.
Yes.
Item 18.
A copy may be provided to me.
No, if we agree, then we'll give it. But if you suppose do not agree, yes.
Item 18.
My lords, item 18. Appeal by the state, my lords. The impugned order is at page 11.
What is that order?
That the honorable single judge held that revision is not maintainable at the instance of state before the Board of Revenue. But this this honorable court in a division bench.
Respondent number 1, 3 and 5. There is a delay of 565 days. And notice on the question of delay has not been sufficient to all the respondents. That is why it has been taken up on orders.
You take steps in respect of respondents, Mr.
Well,
first steps in respect of respondents to be taken within 3 working days. So that is
my lords, kindly take more time. Office is
next
1 week.
Yes. Yes.
Item 19.
And registry, the requirement of the registry to be met as well.
Item 19, my lord, on behalf of Mr. Kuntia, kindly pass over.
My lord, only I have got something to say in this. My lord, on 2 occasions, Mr. Kunti has taken adjournment on the ground that he has been disengaged. The OEOT has disengaged all the lawyers and new counsels have been engaged. But on that ground, 2 occasions he has already taken adjournment. And again, today again he is taking adjournment. I do not know.
Pass over.
Pass over, maybe, but whether he will argue or the new counsel. Again, tomorrow he will say something, say something. My lord, we are being
Item 20.
Please come.
My name is not reflected in the.
Not reflected.
Not reflected. I've already filed.
Sufficient. As reviewed from postal tracking report.
But his name is not reflected.
And I already filed Wakalatam. Already filed Wakalatam my name.
He has filed Wakalatam.
I may permit
We'll
it.
give short accommodations. He also will be ready on that day. We can. You are from Cuttack only. Are you from Cuttack?
Yes, madam. I am from CJ.
Whichever date you want, we will give you.
As your lordship wish.
No, whichever date you want. Choose one date from the calendar. Pull down the date.
This is permitted to file complaint.
This is March.
I have
That we will go to April.
I have filed to complaint.
30th you do. All right? 30th.
But one thing is he is avoiding to file his power.
No, we'll give the letter.
By exercising fraud, he has been.
Now we'll record his submission. Three, so submits that he has entered appearance for
Project number 6.
Response number 6. And 6, a short accommodation for filing what?
On counter.
Is it WP?
WP.
With appeal, where is the counter?
I filed objection.
No.
It is a bar of
You cannot do exam. Appeal. Whatever papers were before the learned single judge, only those papers.
Yes.
His request for filing objections is rejected. Yes.
I put up 13.
30. 30th or
30. Yes.
Item 21.
Item 21 is work charge employees regularization matter, pensionary benefit for pensionary. Lordship have decided work charge pension matter. Okay. That judgment I have.
No,
please. It is the a batch of cases your lordship decided.
See, change this and give brother. Change date and other things.
Yes. This is the one.
Have you rectified?
This is the one relying upon that Basanti Devi case. Basanti Devi is the leading case that your lordship referred.
So this is the one that we have to relapse.
Yes. Or Basanti Devi, whatever. In this case also Basanti Devi has been relied.
In
this
same order
to be passed, relying upon Basanti Devi.
Changes.
Relying upon Basanti Devi.
To be changed, date. So I just must put the yellow pen. Look into. This also will go.
In this case, the respondents completed 10 years of service.
Whatever we have seen covered by same judge. Same order. Okay.
Here in the case, the state has filed, of course, there is delay. I have appealed for the respondent. But item 71 is the same. Command judgment has been challenged. But those judgment regularization, you also have delivered the judgment one exactly same. Here the rather
just give a copy to Mr. Pandey.
Say 122. Mr. G was appearing in this case. Other cases are also there.
The 22 and 71.
71. Same arrangement of common judgment of the single judge. Batch of cases, Hon'Ble University. State has filed that.
But state appeal filed.
State has filed. Well, as we look to the judgment of the Hon'Ble single judge, paragraph 9, exactly the same. Those Jago and other things you also have followed and you also have directed. Even though where there is no sanction for it. Here also in the present sanction post, that is also the finding.
This appeal by this intra-court appeal to the state seeks to call in question a learned single judge's order dated 18 to 2023, whereby
appropriate, reprobate that doctrine your lord.
My brother's judgment, in fact, brother has written it.
Brother's judgment. Lordship judgment.
Reminds me of
Rather, your lordships are more eloquent than the Honorable Supreme Court.
What the last
69. But this judgment was delivered prior to judgment.
It was a
I'm not sure judgment 800 could be including judgment. Same thing.
But the last operative person, you have to find out where the operative person is. Yes.
That is plain.
Not state.
Base?
What you have written?
Paragraphs.
Whereby each. Whereby respondents WP number so and so having been favored, relief has been accorded to him as under.
12.
Correct?
12.
12 and 30. First one. The subject matter of this appeal is substantially similar to the one in writ appeal number 1222 of 2025 between State of Orissa and another versus Ranjan Kumar Rawat, heard and decided by this court, by the order dated 21/1/2026, whereby appeal of the kind has been negative. First one. Learned senior advocate appearing for the respondents rightly submits that similar cases should be decided similarly, subject to all just exceptions into which argued case of the appellants does not fit. First one. Next one. In the above circumstances, this appeal being unworthy of merits is liable to be and accordingly dismissed. First one. The order of the learned single judge shall be implemented within an outer limit of 8 weeks. Implemented, and compliance report shall be filed with the Registrar General of this court within an outer limit of 8 weeks hearing, without giving scope for contempt action.
71 is same.
71 also same.
Date of judgment will be changed.
71 date of judgment will be changed. Yeah.
All cases you also condone the delay because there are some delay.
In 71, delay has been condoned.
Here we go.
Item 23.
Item 23, the rehabilitation, that is matter RA rules. That came subsequently in 4/4/2025 new rule. Still on a singular, it is directed for consideration of the old rule. Now the old rule, we have to consider.
Judgment.
No, yes, covered by many judgments.
I am supplying.
Covered by.
Not notification.
No, we have given one judgment on this only. Do you have that judgment copy?
New.
Mr. Panda, you had argued that matter.
Yes, I will supply, but hard copy I'm only having soft copy.
No, sorry, you can give that. Which is that WP?
WP Millard, that is 16808 of 2022. WPC number 16808 of 2022.
Take up that thing.
Also quoted the new rule and
give that number once.
WPC number 16808 of 2022, order dated 23/6/2025.
The state and its officials are the appellant in this infra court appeal. First one. They seek to lay a challenge to a learned single judge's order dated 1/11/2023, whereby respondents WPC number 33988 of 2023 having been favored, relief has been granted to him while para 6 as under. Next paragraph. We suggested to the bar, which fairly agrees, that the subject matter of this appeal is substantially similar to the one in WPC number 16808 of 2022 between Ganapati Sethi versus District Judge Ganjam.
Yes.
Disposed of on 23/6/2025. In view of the amendment to the Odisha Civil Services into brackets rehabilitation assistance bracket rules, which year? 2020. Wide notification dated 4 April 2025. Full stop. Next paragraph. At paragraph it should be like this actually. It should be this see WPC number 15193 of 2020.
In that order, your lordship has specifically clarified 15193 of 2022.
Correct. 15193 of
2022.
Similar. Rest of the things will change. Identical order will make it. So let there be no confusion. Okay. Identical. Yes.
Item 24.
My lord, item 24 and 25, I seek for an adjournment for next week.
24 is covered, Your Lordship.
Covered?
Yes, Your Lordship.
Sure.
My Lord, may kindly see page 21. That is the impugned order that has been disposed of in terms of WPC number 14788 of 23. It is on consent. It is contended by the learned counsel appearing for the parties that the issue
covered by the order passed by this court in
Mitarani.
So.
My lord, this is the judgment passed in that.
Is it DB judgment?
Yes.
Show to Mr. Pandals.
My lord.
That is identical order.
Identical
only
order.
Dates to be changed.
Your Lordship, the judgment basing on which this writ application was disposed of with the subject matter of challenge, that writ application was confirmed in writ appeal. This is the order.
Sailasutta Devi.
Sailasutta Devi is this one. This is
No, we have disposed of this matter in terms of that Sailasutta.
My lord.
Huh? When you see this order you have given, na? You change the date and the other things so that everything will be in that only. Otherwise, your client may be put to this.
Only one more thing, Your Lordship. In the morning, I got a good knowledge. Everyone has been extended the benefit since the writ appeal is pending.
Well, in this case, what?
I'm sure
the implementation order.
was appointed in the year 2006 and received benefit 97. Serial number 1 to 10, other pages. They have already got the benefit. The last column, Lordship, since Robin and Das, the respondent, effective date of joining the last
Rest of the people are granted a benefit.
Because case pending at Honorable High Court.
This is the case.
My lord.
The subject matter of this petition is appeal is substantially similar to the one in WPC number 14788 of 2023
between state board, that is Mita Rani Mahanti versus state of Odisha.
Disposed of by the coordinate bench of this court.
No, Your Lordship.
No.
14788 is a honorable single judge judgment. That was challenged in this one.
1 second. By another learned single judge of this court, wide order dated 14/7/2023, granting benefit to the respondent, to the employees of the kind. Right. First up, we are told that writ appeal number, the state told that the state and its officials had preferred writ appeal number 247 of 2024 against the said judgment, and that the said writ appeal came to be dismissed by a coordinate bench of this court, wide order dated 25/11/2024. First up, in the above circumstances, this appeal also meets the same fate and accordingly disposed of. First up, appellants shall give effect to the order of the learned single judge within an outer limit of and report to the Registrar General of this court within an outer limit of 3 months. Yes. In as much as to other similarly circumstanced persons, benefits have already been accorded. Benefit has already been accorded. Why not it is notification? Why the
that is the RTA information, not sure. Third page.
Why the
the order of the AB 22.
As has been inspired, what you are wide implemented, as has been reflected in the RTI
information at 24/12
dated 28/1/2026, issued by ABECO/CUM/PIO. Additional BEO, ABEO, come PIO. Person.
Raghunathpur.
Ersama. This is Ersama. Information officer.
Ersama.
Item 25 may be called 1 week after.
2 weeks at the request. Next.
Item 26.
Let the president of
Yes.
I will teach you. When the High Court appeal has been filed challenging the judgment dated 21st June 2024, passed in WPC number 222668/2016.
What does it say?
It's the petitioner has approached the state government to bifurcate the existing Gram Panchayat.
Bifurcate the Panchayat.
Gram Panchayat. As per section 3, subsection 3 of section 3 of the Gram Panchayat Act, it says that in judgment also that has been quoted in page 50, that no gramo shall, as far as may be reasonable practicable, be constituted with a population of less than 2,000 and more than 10,000, but in no event
shall a village be divided and a part thereof included within the gram. That means, but the Lawrence
It should not be below
2,000
It should
and
not be above 10,000.
When the population exceeded 10,000 of the existing gram panchayat, the villagers approached for bifurcation of the existing gram panchayat.
As far as possible.
That has been rejected on the ground that the population of a village is not more than 1,000. But the village and the gram is different. So many villages constitute a gram panchayat. There is no condition precedent that the village should consist of population of 1,000. That is condition precedent as far as headquarters of the gram panchayat is concerned. As per notification by Annexure 1 also. But the learned Honorable Single Judge has said that as the population is less than 1,000 of particular village, the bifurcation is...
No, assuming that it is more than that. Where is the duty? Where is the duty? These are all left to the decision of the government.
Government has rejected.
We direct them to do all
yes,
that.
The government, as per notification and the section provision of Act, there is no condition precedent that has been rejected.
No, you are not point. You are not mind. We have accepted the doctrine of separation of powers. Certain jobs are only meant for government, and certain jobs are only meant for us. Other jobs are meant for the legislature. This is doctrine of separation of power. That power that is given under the Act to the government to bifurcate is a governmental function.
Yes.
How can we, even if it is wrong,
then that has
you can go for election and defeat the government of the day.
That has been rejected on that ground.
Correct.
As per notification.
Assuming the section uses the word as far as possible. Where is the duty? What is meant by as far as? Which is the judgment of the apex court.
When there is no condition precedent in the notification, under the statute, there is no notification.
Let me agree with the single judge's order. First off, we have also noted the language of section 3, which employs the expression as far as possible. First off, there are certain things with our constitution, while the Ram Javaya Kapoor versus State of Punjab has recognized, does recognize the doctrine of separation of powers. First one, that has been held to be a basic feature of the constitution in Indira Nehru Gandhi versus Rajanarayan. First one, the writ court cannot run a race of opinions with the executive. First one, in the above circumstances, the appeal being devoid of merits is liable to be rejected, and accordingly it is.
The executive should run as per the provision of the Act.
Next.
Item 27.
My lord. It's a writ appeal, my lord. All these three lords may call this matter tomorrow.
Next week?
Yes. As your lordship please, I have responded.
Yes.
Next two.
Up to 30 man.
No. Thera hoga sab.
Eta hoga.
Thera sab hoga. Thera covered matter. Item 28.
Item 28.
28, 33 already covered, already said, my lord.
28
to 33. That grant of pension account in the period of the contractual period.
Contractual service.
Contractual service. Already. Anand Das case, we said in the Anand Das case, my lord passed the order.
Any delay is there?
Delay of some limited days.
28, 29,
126 days.
170 days delay.
Will control delay.
I might. Already control in those cases.
To be conducted. Similar. I have to look into. You appear for
Similar matter, 139, my lord.
Up to 28, 29,
30, 31, 33. 30,
32 is not it.
30, no, 20, up to 20, 31, there are 33. 32 is not my place. And 139. And 139, my lord.
39 also.
Same. 139.
139, finally.
29, 30,
139.
32, sorry,
31.
31, 33, and
139, my lord. 139.
139.
My lord. Obliged, my lord.
Item 32.
My lords, item 32. 32. Impugned order at page 8, my lords.
To count service from the initial entry to ends. That is in terms of Niranjana Biswal's judgment.
My lords, that in our appeal memo, page 5, we have distinguished that it is the same.
How?
Niranjan Biswal.
Yes, show what it
The factual difference is there, my lord.
Differences. How they are relevant. Differences may be there. How they are relevant to the issue.
My lords, in Niranjan Biswal case, that person was working as secretary of the Gram Panchayat from 74 to 2009.
Yes. How status will be complete. He may be different. Father's name will be different.
He was not holding a civil post, my lords. Niranjan Biswal.
Still it is there. Still, how that is relevant? Question is whether service should be counted from the entry. That is the question. So many differences will be there. Somebody will be born on Monday.
My lords, in fact, they have to consider it in terms of this. Such opportunity of hearing was not given.
We are giving you. Tell what is that? You take, you read and come. Difference that is relevant to the adjudication, not some difference. Yes.
Item 34.
Tomorrow. Next week, that's the request.
Passover.
Someday you could see how many members are for the calendar, see the calendar. Full. So we got
Item 35.
Who? 35. Anil Kumar. Anil Kumar. Only 2 weeks to enable advocates to appear counsel for the opponents to argue, come and argue. Yes.
Item 36.
Madam, in this case, we are the respondent, madam.
Yeah. Yes, for the respondents.
6 also.
Right?
5, 6.
State appeal may not, that will be. But there nobody is raising what to do.
So my lord is moving very fast to know.
Tomorrow is for calendar is
Supplemental list any day. Supplemental list. That is the cover, my order in the other division batch order is with us. That is also regarding the delay as well as the apex court decision.
We will continue delay this.
Suppression of fact. Suppression of fact. Yes. Similar matter already
Mr.
state
Devra, they have made your job now very tough job.
in the one part they have regularized it and opened the GPF. So in the other way they are challenging this before my lords.
My lord,
This is what true.
G. Narayanaswamy Reddy for government of Karnataka.
Similar. Similar. And the honorable
Dalip Singh versus State of Uttar Pradesh. Another matter, K.T. Sharma versus Steel Authority of India.
At least give that.
It's
We can finish.
Oblige.